I need coffee too, Margaret. Hi. Hi, friends. Hey, Miss P. Lola says it's me, P. Lola. I'm going to struggle reading this. It's me, P. Lola, LOL. Actually, Lola went to doggy heaven. Now it's P. Bella, LOL. I'm sorry about that. I'll listen to you while working, cleaning, and driving. Hope y'all have a lovely day. I hope you have a lovely day too. And no texting while driving. How many times have I had to tell you that? I know you do it when you're stopped and you're parked and blah, 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 but I don't trust you, little lady. Hey, Miss Donnie. Mary Lou. Getting ready to go be polite to the public. You're already polite, like I said. You're already polite. Some folks don't need to be polited. Be polited to. Is that the right way to say it? No, it's not. But hey, Miss Savage Geese. Morgana Banana, hey, Miss Margaret. I need coffee too. Um, hey, Ruth. Good to see you, honey. Yes, it is when people yelling at me over meat prices. Well, they don't have no business yelling at you. It's not like you're the one pricing the meat, right? So why are they yelling at you? I don't get that. They got no business yelling at you for nothing. Send them my way. Hey, Ruth. Hey, Sherry. Sherry, I had some caramel cappuccino, but my cup is empty. I gotta go get another cup. I need some more coffee. Anxiously waiting my Amazon packages. Ooh, what you got coming, Mrs. Savage Geese? What you got coming? I got a bunch of product that I have to get packaged up to ship out today. Well, I got to package it up today to get it shipped out tomorrow. Um, so there's a lot of things going on in the courts today. We have the Corey Richens hearing is currently going on. I haven't watched any of it yet, and I don't know what this hearing is about, but I guess we are about to find out because I wanted to watch it. And then Rob Reiner's son is supposed to have had a hearing today. What else was there? Oh no, he's in court for arraignment. That's what he was in court for. His first court appearance. And then the Uvalde school shooting officer on trial. They're supposed to be having a motions hearing today, but it says it won't start till 2:30. But the hearing was supposed to have been this morning. So I don't know what that was about. I mean, why we're waiting on that. I don't know. I'm looking. Um Ooh, oh, and you guys, I slept so good last night. Oh, you would not believe how good I slept. I slept so good. I laid down. It was about 8:30 ish. Fell asleep. Um, there was a Lindsay Clancy hearing this morning too. Where at? I didn't see that. I didn't see that. Where was that at? And what is this? I missed this whole lip filler mom murder trial. When that didn't last very long, did it? Looks like there's only a couple videos. I don't even know what that was about. But um I slept so good. I did. I slept so good. So Monday and Tuesday was a horror story, right? And then last night it was only opening and verdict on the lip filler trial, really. Okay. They didn't stream anything else? Weird. Hey, Donnie. Good to see you. But yeah, I slept so good. And I didn't even take my nighttime medicine. I was too tired to get up to go take it. So I just stayed. I fell asleep. It was about 8:30. Um, and I laid there and was like, oh, I need to get up and go take my nighttime medicine, which the only nighttime medicine, now I'm yawning, my only nighttime medicine that I have to take or that I can take is the one to help me sleep. But I don't take it all the time because it don't really work for me. But I was like, meh, I'll try it, And I was too tired to even get up to go take it. I'm like, well, if I'm this tired and ready for sleep, then I'm just going to lay here and sleep. And I slept so good. And then I woke up. It was about 2 o'clock this morning. And I got up and I went to use the bathroom and get some water. And I let Poppy out to use the bathroom, let her back in. I think I hem-hawed around on my phone for maybe 5 or 10 minutes and then went back to sleep and slept. I slept so good. I hope I sleep that good again tonight or even better. But I woke up this morning and was like, yay, I slept so good. I wasn't walking around like a zombie with my eyes burning out of my head and told you was recovering from the holidays. I know. Yeah, don't forget to smear your DNA all over that thumbs up button, please, and thank you. That is the best, Donnie. It was the best. It was such good sleep. But what was I going to do? Let me run to my email real quick. Hold on just a second. Oh, hey, Patricia. Life-changing sleep, right? Good to see you, Patricia. Hold on, let me go to my email real quick because I got a link in my email that I sent myself. Dun, 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 dun. Where is it? It should say from me. There it is, me. Okay, let me open this up. I'm going to share this with you guys real quick. This is a story I was talking about Chad Daybell's cousin the other day. Okay. Here we go. Sharing this tab. All right. So here we go. Nibley couple arrested after death of 18-month-old daughter. So this is the photo. Let me make it bigger. See if it looks bigger for you guys. Okay. So this is the photo of the mom and dad. And they apparently have another little kid that's a little older. I think 4 or 5 years old, maybe. And then the little girl in the mom's lap is Ruby. This is the little girl that passed away. Sadly. Heartbreaking. Wait, who's Sperry? Hi, Sperry. Who's Sperry? Oh, Sherry. AJ is stepping down from the Reiner case? Really? Is that going on right now? Is that on? Oh, I don't see it yet. It still says waiting. believe it cannot be streamed live and will be posted immediately after it's finished, is what someone in the Nick Reiner case has said over here on Law and Crime. I'll keep that tab open just in case. Oh, it's on Court TV? Dang it. Hold on a minute. I did too, Patricia. I'm not going to lie. Unless he had a really good defense. But I'm just going to say that being an addict does not make one not guilty. You know what I'm saying? Commercial now. Okay. Is it a live stream, Donnie, of like the arraignment, or is it just like newscasters chitter chattering? Ooh, I like Philip Dubé. Okay. So, in the meantime, we're going to talk about this little girl, Ruby. Chitter chatter. Okay. Because I don't want to get struck by sharing something like that. You know what I mean? I didn't want to get struck. But if it were actual like courtroom stuff in the courtroom live coverage, then I could share it. So Ruby Murray is the little girl in the pink dress with the little orange crown on her head. She was 18 months old. And this is the picture of the mom and dad. Okay? They're the ones charged with her murder. Hold on just a second. I have to do something real quick. Hold on just a minute. Okay, I'm back. Welcome back, P. Lola. Broom in your hand, huh? All right, so I'm going to read through this. And yeah, we're just going to read through this. It says, Logan, Utah, December the 4th, 2025. A Nibley couple has been arrested in connection with the malnutrition and dehydration death of their 18-month-old daughter, Ruby. 31-year-old Mitchell Chestnut Murray and Carrie Marie Murray, who works as a patient care nurse, have been arrested for the investigation of alleged aggravated murder, a first-degree felony, aggravated child abuse, intentional or knowing, a second-degree felony. The Cache County Sheriff's Office began an investigation of Mitchell and Carrie Murray after the March 19th death of Ruby, who investigators say showed signs of neglect. The investigation found evidence of a severe pattern of neglect leading up to the infant's death, a news release from the CCSO says. Using data recovered from baby monitors and surveillance cameras, investigators say they established the following facts regarding the 18-month-old child's pattern of life during the 4 days, 96 hours immediately preceding the date of death. The child was documented as being outside of the crib. Oh, I can't hardly read this. Outside of the crib for a total accumulated time of 6 hours and 15 minutes. So in 4 days, in 96 hours, that baby was in her crib all of that time except for 6 hours and 15 minutes. The total time another human being was identified as being present with the child in those 4 days was 49 minutes and 15 seconds. During this 96-hour time frame, a total of 6 diaper changes were identified. That blows my mind. So in 4 days, which is 96 hours, the baby was only outside of the crib for a total of 6 hours and 15 minutes in 4 whole days. And in 4 whole days, she was only in the presence of another human being for 49 minutes, less than an hour in 4 days. During this time frame, a total of 6 diaper changes were done. It says the findings of the medical examiner confirmed that the infant died due to complications arising from malnutrition and dehydration. Keep in mind, all while, I have not yet determined or identified whether it's the man or the woman that is the cousin. I've heard both. Not that both are his cousin, but I've heard that the man was his cousin, and then I've heard that the woman was. I don't know which, but I think it's the female, Carrie, the mom. I think she is the cousin of Chad Daybell. Again, this sort of behavior must run in the family. So, it says based on these facts and the medical findings, Mitchell and Carrie Murray were taken into custody. The Cache County Sheriff's statement says the Murrays have been booked into the Cache County Jail on charges related to homicide and child abuse. The Cache County Sheriff's Office extends its deepest and most heartfelt condolences to all individuals affected by this tragic case. And there's another picture of them. And I'm assuming that's Ruby in the back here. I don't know. All while this mother is a nurse. A nurse. There was another couple of articles that I seen that I wanted to show. Let me go grab them real quick. I wish that I had saved them or bookmarked them, but I did not. Hold on a second. Mitchell. Let me see if this is one of them. Hold on. Okay, here's maybe a good one. Let me open this up. All right, let me share this tab. Okay, so Mitchell, it is the man then. It's his second cousin. Okay, I thought I had heard him first. Then I heard from somewhere else that Carrie was the cousin. And then, so, let me see if you guys can see what I'm seeing. Okay, here we go. Yeah, you can. Key takeaways. It's going to be some of the same things, but there's some other additional information in here too that I thought was relevant. Hold on. Okay. Cache County couple were arrested for investigation of murder in their daughter's death. Let me see. Ruby Marie Murray, the baby, died on March 19th. She weighed approximately 17 pounds at the time of her death. Listen to this. Her mother told police she found her daughter deceased in her crib, according to a police booking affidavit. Now, again, I tried to find the probable cause affidavit. I can't find it. As emergency crews were responding, 911 dispatchers tried to get Carrie Murray to perform life-saving efforts. But Carrie informed dispatch that she was a nurse and she believed the child was beyond help. The affidavit states. When paramedics arrived, they told police that they believed rigor mortis had already set in. Follow-up investigative steps conducted by the Cache County Sheriff's Office identified a severe pattern of neglect. Using baby monitors and surveillance cameras, detectives learned that during the last 4 days of Ruby's life, she was only out of her crib for a little more than 6 hours, and the total time another human being was identified as being present with the child was 49 minutes and 15 seconds, and the 6 diaper changes. We read that. Deputies further noted in the affidavit that the child's crib was in a bedroom where there was a space heater running, which was set to 68 degrees Fahrenheit and was noticeably warmer than the rest of the home. "68 degrees doesn't sound right. I read in another article that it was much warmer in the baby's room than the rest of the house. And this was, or maybe I'm mistaken. I'll have to double check that part. The interior of the crib, it said, was very dirty with old pieces of food. Underneath the mattress was trash, wrappers, and waffle particles, according to the affidavit, like frozen waffles. The findings of the medical examiner confirmed that the infant died due to complications arising from malnutrition and dehydration. When questioned by detectives, Carrie Murray said the last time she saw her daughter before her death was on March 17th about 3 a.m., but did not see her on March 18th due to work. Carrie was asked by investigators about Ruby's food and water intake and were informed that Ruby was provided a sippy cup in the morning and evening. Carrie also informed investigators that Ruby was usually fed waffles for all of her meals, and she typically ate them in her crib because they are not table people. And Ruby never liked someone to feed her. Well, why is she only eating waffles? Carrie Murray also admitted to not viewing the baby monitor app in months. According to investigators, when asked about the daily routine of her 4-year-old, Murray allegedly told investigators that she was unsure, including when he woke in the morning. Oh, wait. Sorry. When asked about the daily routine of her 4-year-old son. Okay, the older kid. Murray allegedly told investigators she was unsure, including when he woke in the morning. So what in the name of God, if they're... What's the 4-year-old doing whenever the baby's in the crib? What's the 4-year-old doing? Mitchell Murray told police he works from home and is on his laptop a lot, both working and playing games on his PC when he's not working. Another guy playing games whenever his kids need taken care of. God help me. Mitchell explained what he termed crib days. He explained that crib days were days where Ruby remained in her crib all day while he worked. He claimed this would occur 1 to 2 days per week, but he claimed he would check on her 2 or 3 times during the day. Good Lord. Investigators reviewed surveillance video from inside Ruby's room for the final 4 days of her life. They found that during 8 hours on March 14th, Carrie and Mitchell Murray had 36 minutes of interaction with Ruby in her bedroom, gave her food once, and changed her diaper once, according to the affidavit. On March 15th, Ruby was out of her crib for just under 90 minutes the entire day. On the 16th, there was footage of the entire day. Review of that footage showed Ruby was allowed out of the crib for 4 hours and 44 minutes. The majority of that time, Ruby was left alone on her bedroom floor. The total interaction Carrie, Mitchell, and their son had with Ruby on March 16th was 9 minutes and 42 seconds. On the 17th, Ruby was out of her crib for about 5 minutes for the entire day for 2 diaper changes, the affidavit says. So that was the only time she was out of her crib was for a diaper change. I mean, at least they changed her diaper, thank God. Investigators say Ruby was never taken out of her crib on March 18th. The total interaction Carrie, Mitchell, and their son had with Ruby on March 18th was 49 seconds. Her diaper was not changed on March 18th, according to the arrest report. Detectives who watched all 4 days of the video surveillance footage also noted that Ruby did not exhibit normal sleeping patterns for a child and did not seem to differentiate night from day. It was also observed that there was loud rock pop music played through the Amazon Alexa in Ruby's room that appeared to interfere with her ability to sleep at times. Well, yeah, I mean, who can sleep with loud rock music playing? During a second interview, Carrie Murray allegedly admitted that she and Mitchell Murray interacted with Ruby even less during the previous fall, that they bathed her about once a week, and that Ruby had only eaten baby food once or twice and mainly received waffles, quesadillas, or a sippy cup, according to the affidavit. She also stated that Ruby needed music to sleep, and Green Day and Fall Out Boy would typically be played in her room all night. The sheriff's office alleges that the Murrays showed a depraved indifference to human life, you think, and knowingly engaged in conduct that created a grave risk of death to Ruby, thereby causing her death by failing to provide her with the appropriate nutrition and hydration, leading to her death from dehydration and undernutrition. My God. My God. Hey, Gail, good to see you. I don't know, Morgana. What she said, why do these kind of people have kids? It's obvious they didn't want them. I mean, I don't know about the 4-year-old, but her, they apparently didn't want. I don't get it. I don't get it. I don't get it. But yeah, this is Chad Daybell's cousin, the mom. And they're I've read from other articles that they're Mormon as well. Okay, we've got some movement over here in the Nick Reiner case. Hold on. It started what, about 3 minutes ago? Let's move it over here real quick. Share this. Nick Reiner arraignment scheduled this morning. Hold on, let me get rid of this. I got 15 tabs open. Okay, I'm gonna hit play. Looks like they're opening up. God, who's yelling? Absolutely, Donnie. When I read that, it totally reminded me of what's his face, the one that didn't have the, you know what, to go to prison for what he did. I forget his name. His name isn't even important.
I can't really. There's no room. Is that okay? No. Okay.
I hope you know that you can be heard,
Oh,
Mister.
Something just fell off it. I don't know what just fell off. I don't know. I just laid it on top.
Something fell off of it. Hey, Miss King. So it's a big court day. Lots of things happening. The Nick Reiner arraignment is going on today. And did you know that Donnie said she heard on Court TV that AJ has stepped down from being his attorney? Did you know that? We've also been talking about the little girl, Daybell's cousin's daughter that passed. You want to rewind and watch that too? I don't know who's yelling. Alan, have you seen that animal video? What, Donnie? I don't know what you mean. I need more coffee. I need more coffee. Maybe his other partners are taking the lead. Oh,
No. Sometimes like if you plug it in, it's already been on. It doesn't see it, so the power back to cycle it. Come all the way back down.
downtown LA full of hollering. Well, I've got the volume all the way up. So is this like the, what are we looking at? These are like cage bars. Where are they? Are they in like the, now they're back to the screaming and hollering. I have no idea, Margaret. It looked like they were in like the back of a prison truck or something with the cages, like a transport vehicle. Okay, here's the judge. She's pretty. Aaron Spencer is January 26th. Dee Dee is going to cover it in person. No cameras allowed. Wow. Where is that at again? Because I think if I'm not mistaken, Dee Dee is in around Illinois. Unless you're talking about somebody other than Defense Diaries. Arkansas. Oh, wow. Okay. Because aren't him and his wife in like Chicago? Bob and Allie, aren't they in Chicago? I need a pair of scissors. Ugh. I think so too. I'm gonna have to go make me some more coffee, you guys. Feel like I'm getting the sleepies. Nick Reiner arraignment scheduled this morning.
December 25, CJC F08098.
Good morning, Your Honor. Alan Jackson, on behalf of Mr. Reiner, who is present in court out of custody. I'm sorry, in custody.
Thank you.
Good morning, Your Honor. Habib Balian for the people.
Your Honor, we have a matter of housekeeping that I'd like to address in chambers in dealing with the 10 subpoenas that are outstanding. There are 10 current subpoenas that are outstanding. We would ask that body attachments be issued and held for each of the 10, specifically with subpoena number 4 on the list and subpoena number 10 on the list. Counsel for both of those individuals or those parties have appeared in court. They're here with us today. We have no principled objection to an extension of time for them to comply with the subpoena, but to maintain jurisdiction, we would ask that body attachments be issued.
I don't have a list. I'd like to get a copy, and I haven't seen the proof of service, but I assume the court.
Did counsel for 4 and 10 present?
Yes, Your Honor. I'm not sure which number I am.
Number 10.
I'm counsel for number 10, and we do object to issue if that would resolve the court's concerns about retaining jurisdiction. However, we see no reason, given our appearance and the fact that we are here to issue a hold of body attachment.
And counsel for number 4?
In council number 10's statement, I don't see the necessity for issuing a body attachment. I too will stipulate the jurisdiction without necessarily waiving any objections we ultimately may make. But given my newness to the matter, I don't see the necessity of having a court order issued against an individual in this circumstance.
Fair enough.
Thank you, Your Honor, and just to be clear, we do also reserve all of our objections.
Yes, and so, but as to the remaining
Donnie.
numbers, that's 1, 2, 3, 5, 6, 7, and 8. Those, the court will issue body attachment and hold it until the next court date.
And
And
thank you. We have no objection to counsel's representations, given the fact that both have graciously submitted to jurisdiction with regard to 4 and 10. We think that's appropriate.
thank you. Once again, the court will issue and hold 3, 5, 6, 7, 8, and 9
Thank you.
until the next hearing date. And we'll
Does the
seal.
court have a list?
It does. And the court will seal that list as well.
We've asked,
People have a copy or?
we've asked that the court seal it specifically because it is ongoing defense investigative data or evidence that we recover or we get. Our counsel on behalf of Mr. Reiner gets, and that is discoverable. We'll comply with our counsel will comply with all discovered allegations at that time.
Can you address the council's request to provide a copy to the people?
That's the point. We think that should not be done because that would implicate ongoing investigative efforts by the defense, and it would compromise Mr. Reiner's right to a fair trial and his right to maintain his investigation with some level of confidence or confidentiality, I should say.
So at this time, the court will just seal it until the next court hearing date.
Thank you.
And how else would you proceed?
Your Honor, at this time, I, on behalf of Workman Jackson and Quinn, and with Mr. Reiner's understanding and consent, would ask to withdraw as counsel of record based on the conversation that we've had in chambers and the explanation that we've provided to the court in chambers. We feel that we have no choice at this juncture but to withdraw as counsel and ask to be relieved. The Public Defender's Office has been notified. We've had conversations with them. They are here. They're staffed. They're ready to take over. My understanding is they are ready for the appointment immediately, forthwith.
Good morning, Your Honor. Kimberly Green from the Public Defender's Office. That is correct.
So the court will raise, and so that firm is relieved as counsel of record, and the court appoints the Public Defender's Office to represent Mr. Reiner.
Thank you.
Current council turnover, any items that they received.
We will absolutely comply with that. We've already begun. The mediation has been met.
Your Honor, there's a protective order issued by the court in place regarding the handling of discovery. Order that's remained in place for now, and we will serve a copy of that on the Public Defender's Office along with the discovery we provide.
Yes, the court will order that order.
Me from Mr. Balian raises a very sage point. I'm under a protective order not to provide our discovery to anybody else. That would text providing the information only to Ms. Green in her office. Then I can be in full compliance with the protective order.
Anything to the people, any response to that request?
No problem. I believe the protective order spells out that it covers Mr. Jackson's firm as well as any successor counsel.
Thank you.
You can provide everything to Ms. Green.
Thank you.
Thank you.
So I'm confused. Is he going from Alan Jackson to a public defender? If that's the case, then Morgana, I would assume it's a money thing. I don't know.
Back on the record in People versus Nick Reiner, case number 25 CJC F08098.
Good morning, Kimberly Green, DRTE, and the Public Defender's Office on behalf of Mr. Reiner, who again is present.
Thank you.
Good morning, Your Honor. Khabib Alien, representing the people of the state of California.
Thank you.
Your Honor, with the court's permission, we'd ask to put over the arraignment one last time to February 23rd, if that date is appropriate.
That date is fine, of course.
Thank you, and I will work with Ms. Green to get her discovery prior to that date.
I'll take a waiver for you. Entitled, you have a constitutional statutory right to a speedy arraignment. Your counsel, Ms. Green from the Public Defender's Office, is requesting that your arraignment be continued to February the 23rd, 2026. In this department, do you waive your right to be arraigned today so that your matter may be continued to February 23rd, 2026 for arraignment?
Yeah, I agree with
Is counsel doing that waiver?
I do, Your
The
Honor.
court finds that the defendant has made a knowing and intelligent waiver of his right to a speedy arraignment, and that his counsel of record joins in that waiver. Matter set for arraignment in this department, February 23rd, 2026. Bail remains at no bail. Anything further?
No, Your Honor.
Okay, thank you.
Thank you.
That's the end of that one. So I'll loop it.
This is your right, producer, repeat for the court proceedings.
Okay, so now we're getting some feedback from the that's definitely from their what do you want to call it? Media truck, you know. That was crazy. I mean, if I was Nick Reiner, I'd be like, going from AJ to no, there's nothing wrong with public defenders. Don't get me wrong. They're some of the best of the best, right? But also I would be like, dang, you know.
We're ready. So calling People versus Nick Reiner, case number 25 CJC.
Okay, so they're just playing.
098.
Okay, so they're just playing this over again. I wonder if they're going to have a press conference. I mean, they've got all these mics, right? We're on live now. Either his family don't want to support him or he doesn't want their support. I mean, yeah, you're right. That it could be either way. But I want to know. I want to hear it. Like, do you think AJ will speak? You think he will?
Test 1, 2, check.
All right. Well, while we're waiting on this press conference, I I'm going to go get me some coffee, okay? The family is releasing a statement. I'm wondering if this presser is in real time now or if it's still a behind feed. You know what I mean? Are you seeing anything? Isn't that guy right there from Court TV? What's his name? This guy right here. Isn't he from Court TV? But I forget his name. Okay, I'm going to go get coffee while we wait. I'm eager to hear what Alan Jackson says or what the family statement is anyway. Matt Gutman. Okay. He's with Court TV, right? Oh, CBS now. Okay. Sound like somebody said, I love you, Alan. I love you. Did you hear that? Let me rewind that. Listen. One more time. I don't know who the guy yelling is, but I'm really bad with names, Donnie. Unless it's someone that I really, really know and love, you know. But like I know the guy's face. I just couldn't remember the name. Or apparently the network. Okay, going for coffee. Going for coffee. Oh yeah, yay. I'll be right back.
Good, how are you?
Alan, what's your code for your phone?
Be louder.
How's it going? Are you guys building a wall? Yeah, that's what we're gonna do. This gentleman suggested it. I'll join your wall. Yeah. Look at the guy. I don't want to. Trying to not, and finally he's like, well, I'm not threatening you. And I was like, that's intimidation for him. And he literally turned on me and walked away. I was like,
Because like the statement itself, even verbatim, doesn't hold what you're saying. Context. Not commenting, but it's not happened today.
but they're not reacting.
Just saying.
I'll say that. They're not reacting to vaccine. Back by the elevator, so. Oh, she might have help set up.
Which I mean,
Like a lecture.
yeah, so we could get this and you could do something else. Can we talk to you real quick?
Yeah, because you need to
That's what I mean.
there, yeah.
So I mean, do something up there for 11 for you.
Yeah, if you want to get organized with them, then I'll let them know that's okay. They might take this and
Let me make sure it's got it.
You coming?
He's coming.
I grabbed a sandwich too, and I just now sat down. So
Good morning. As you know, my name is Alan Jackson. This morning, I had to withdraw as Nick Reiner's counsel. Circumstances beyond our control, but more importantly, circumstances beyond Nick's control have dictated that sadly, it's made it impossible for us to continue our representation of Nick. I'm legally and I'm ethically prohibited from explaining all the reasons why. I know that's a question on everybody's mind. We expect the public defender to step in. They've already been appointed and very capably protect Nick Reiner's interests as he moves forward through the system. But be clear, be very, very clear about this. My team and I remain deeply, deeply committed to Nick Reiner and to his best interests. In fact, we know, we're not just convinced, we know that the legal process will reveal the true facts of the circumstances surrounding this case, Nick's case. You know, a lot's been printed of late, over the last 3 weeks. A lot has been printed about Nick, printed about his family, printed about the circumstances. Speculation is in print. On December 15th, in the early morning hours, I was in New York at the time, and I got a call. Me and my team, we dropped everything. And for the last 3 weeks, we have devoted literally every waking hour to protecting Nick and his interests. We've investigated this matter top to bottom, back to front. What we've learned, and you can take this to the bank, is that pursuant to the laws of this state, pursuant to the law in California, Nick Reiner is not guilty of murder. Print that. Print that. We wish him the very, very best moving forward. And that's all I have today.
oh my God.
And another thing.
Is the family still going to make a statement? Here's the public defender. So they cut the feed. Urgh. Why would they do that? I want to hear. They're going to have yeah, not guilty by reason of insanity. I mean, I'm assuming that's what they're going with. But they would have to really prove insanity because in my opinion, an alcoholic or addict does not equate insanity. Let me see. I'm going to try to look and see if I can find. Can anybody else find a feed of the press conference? Because why did they cut it like that? Bunch of poops. Oh, hold on. Oh, it's so loud. Let me turn the music off. Nothing like a yummy peanut butter sandwich at 1:30 in the afternoon, huh? I made one for Big Kiddo, and I was like, that looks weird. That looks weird. Why did I say weird? Oh, because I read it said it just sits weird. I saw that weird word as I was talking about the sandwich and was like, that I made Big Kiddo sandwich, and I was like, that sounds good, not weird. Oh, Patricia, the only thing I will say is that it's a very dangerous stretch of road. It's called Dead Man's Curve or something. Definitely not an excuse for the defendant's behavior. He should be held responsible. Dead Man's Curve. I don't know. Never heard of that. I need to look that up. I want to go. Hold on a minute. Bum, 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 ba-dum, ba-dum, bum, 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 ba-dum. Wait, what'd that say? Duncan is making a major menu change. Starting with Megan Thee Stallion's protein refresher. Oh, Lord have mercy. Go over here and go to YouTube and then type in Reiner. Oh, here we go. Hold on. Hold on, let me rewind it. Okay, that was Alan Jackson. And then after he's done, that's
Work at the
where
time, and I got for the last 3 weeks.
that's where Law and Crime Cut It Off was right after Alan Jackson walked off.
We have devoted literally.
Yeah, that's
And
where I'm at
another.
now is on Reuters. So that female right there at the microphone is the one that
Sure.
was
Ricardo Garcia,
public.
Los Angeles County Public Defender. I'm here with Kimberly Green, the Deputy Public Defender assigned to the Reiner case. I want to say that on behalf of the entire Public Defender's Office, we are incredibly sorry and understand the pain and suffering that the Reiner family is going through at this time, as well as the entire Los Angeles community. The Public Defender's Office and the entire staff, our hearts at this time go out to the entire family. We hope that the community will also understand that this is a challenging time for the entire legal process. We ask for your patience, your understanding as we navigate this process through the legal system, and that we will be available as we can be to address your questions when appropriate. Thank you. We learned, I believe last night or yesterday, that we were being substituted in. I'm going to let Ms. Green answer that.
Briefly this morning, but we haven't had a chance to discuss anything. I spoke to Mr. Reiner briefly this morning. He was understanding that there was going to be a change in counsel. We haven't had any in-depth conversation. I have not. We'll discuss that with Mr. Reiner and see how to proceed. Not at all. It's not uncommon for private counsel to turn over cases to us, so no, nothing about that would complicate the situation.
Hey,
I
Cherie.
haven't talked to him for only 30 seconds, so I have no idea. I only spoke to Mr. Reiner for about 30 seconds this morning. I have no comment about him. I have not. We've had no contact with the family. I don't think they were aware that this was going on until this morning.
At this point in time, Ms. Green will look into the case. We'll speak with Mr. Reiner. And if you have any further questions, reach out to our media team once we have more information ourselves. This just happened today, and my understanding is he was aware of it. Ms. Green spoke with him, as you heard. And as soon as we have more information that we can share, we will share it.
Thank you. No further questions at this time.
Thank you. You can direct any further questions to our media. Green with an E at the end.
Okay. The DA is coming out. Is that what they said? So they're not done yet. Okay. Here they are.
Bachman. I'm the District Attorney of Los Angeles County. With me is Habib Balian. He is the Assistant Head Deputy of Major Crimes. He will be prosecuting this case. I'm here to make 3 points, and then I will not be taking questions afterwards. In our criminal justice system, every defendant is entitled to a lawyer who will zealously represent their interests and do so effectively. So too is Nick Reiner, whether it's Alan Jackson, someone from the public defender's office, or any lawyer. He's entitled to that lawyer, and we'll make sure he gets that lawyer. Second point, in the process of dealing with that lawyer, we will make sure, the DA's office will make sure that that lawyer is provided with full discovery of all the facts that pertain to this particular situation, whether it's interviews, whether it's any type of video, whether it's any type of expert reports. We'll make sure that that lawyer gets the facts necessary to effectively represent their client in a court of law. And third point, we are fully confident that a jury will convict Nick Reiner beyond a reasonable doubt of the brutal murders of his parents, Rob Reiner and Michelle Singer Reiner, and do so unanimously. Thank you very much. Have you spoken with the family? Do you still plan on seeking the death penalty?
He asked if they were planning on seeking the death penalty.
I'll text you later if you got time for coffee. Maybe nice to see you.
All right. Now I'm just wondering if the family has released a statement, because I want to see that if that's the case.
Is that Maeve?
You? Oh my God.
Hmm. Oh, okay, Patricia. I was really confused.
Right now with our attorneys.
Okay.
I was really, really confused. I even Googled it. I was like, what does, because I assumed you meant like the dead man's curve. I thought you meant that as like mental health wise, you know? And so I looked it up and it was talking about a physical road. And then I was like, dead man's curve, mental health. And then it literally came up and said that that's a thing, you know, like a point. Yeah. You didn't realize AJ was, yes, Patricia. He was until today, and he withdrawed from the case. And now Reiner has a public defender. You got to rewind it and watch Alan Jackson. Yeah. And then did a press release. Big stuff. But I'm still waiting on, I see on Popcorn Planet, it says on YouTube, Popcorn Planet's channel says family to release a statement. But when are they going to release a statement? I don't know. I don't know. Let me go back over here and hit the live button. Okay, that live event has ended. So, dun, 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 dun. And I want to know now. I want to go over here and check out. I said something about court watch today, or court hopping, or something like that, because I knew I wanted to see what was going on in these different things. And then today, Corey Richens' hearing is going on, and the last I heard was that her trial was like postponed indefinitely. I don't know if today is about they're setting new dates or what, but we're going to go check that out. Oh shoot, hold on. The motions hearing has started too on the Uvalde trial. They just went live, but nobody in the courtroom yet. So I'm going to put this on pause, and I'm going to go over here and check out Corey Richens real quick. Live hearing. Here we go. Share this tab. And let me X out of that to make it bigger.
Good morning, Your Honor. Brad Bloodworth, Margaret Olson, Lindsay Shervanack, and Fred Burmester for the state.
Very good.
So again, this is the Corey Richens. Oh, wow. Corey Richens here says this is expected to be in court Wednesday and Thursday for a 2-day evidentiary
Wendy Lewis, Catherine Nestor, and
hearing.
Alexander Ramos for the defense.
All right. Counsel, as I understand it, we're here today to address the defendant's motions to exclude 3 of the state's experts. Is that correct, Ms. Lewis?
Yes, Your Honor.
The states recently filed a motion to exclude one of the defendant's experts not on the list for today. We'll address that in some fashion in the future. Yes.
Yes, sir.
Okay. Ms. Lewis, do you have a plan on how you want to proceed?
Your Honor.
It's a preliminary matter. My apologies.
Just thank you, Your Honor. May I-
Of course.
So what was the deal with this? Why he does have a nice voice, Gail. I agree. I like to listen to him talk. I also like to hear the other judge talk in that Sarah Grace Patrick. That judge in Georgia reminds me hardcore of that preacher man. What's that? Is it big time on the TV? What's his name? He's the happy preacher, the one that's always got a good word. What's his name? Can you imagine him saying, "Hey, baby"? Right? No. Hey, baby. Joel Osteen. Yes, Joel Osteen. He's that feel-good judge. That's what I like to call him. Feel-good judge. No, preacher, feel-good preacher. He's one that's always, this is my Bible. It is what it says I am. It does what it says I can do. And it blah, 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 blah. I love him personally. But I call him a feel-good preacher because he don't never talk hellfire and brimstone. You know what I mean? It's always just feel good, surface level stuff. Like there's no meat and potatoes there, I feel like. You know what I'm saying? Does that make sense to you guys? Or am I being a little out there? I can't help it. That's just how I feel about him. I love him though. He's a great, like, motivational kind of thing. But he don't get into the nitty gritty meat and potatoes, the word. You know what I mean? He never says anything negative, which is a lot. Right. Well, I mean, I don't want him to talk negative, but I want him to I want him to get into the teaching, and not so much of the, I don't know. All right. Now we're going to watch part of this, but I do know that the last I heard, you guys told me that Corey Richens' trial was like put on hold. I don't know the whys or the what fors or whatever. But now they're having an evidentiary hearing today. So it says in the upcoming murder trial. So has there been another date set or not? I don't know. Maybe they'll talk about that today. But she's in the courtroom right there. Her in her pretty little emerald green shirt. Mickey, yeah, you said it perfectly. He needs to teach how to survive instead of jump and shout. Well, I mean, yeah, Mickey knows what I'm saying. Yeah. I like jumping and shouting too. Don't get me wrong. Church is church. But I just, I don't know. Need some meat and potatoes. Can't get all full up on a salad, you know. You gotta have some meat and potatoes. All right. Here we go. I'm hitting the play button. And we're gonna go. Always a courtroom full of people at her hearings, though, huh? 2-day hearing, though. Oof. I'm anxious to hear about the other hearing, too, though, in the Uvalde thing. So, we'll probably just kind of see what's going on here with Corey and maybe check in on that tomorrow or something. Because I don't want to miss the Uvalde hearing. All right, here we go.
Your Honor, the state wants to ask the court to make additional findings in connection with its order from yesterday denying the state's motion to determine admissibility of evidence. The court's findings regarding the defendant's financial crimes as it relates to the state's pecuniary gain element argument is clear. In its briefing, the state raised 2 additional arguments that the state—
Oh, wow, they bumped it up quick then.
The first is that the defendant caused Eric Richens' death to cover up her financial crimes, and this proves an additional motive as well as the identity and intent elements. And the second argument is that the defendant's—
I'm sorry, no, I just am having trouble hearing. I need you to pull down the mic. Thank you.
And the second argument, Your Honor, is that the defendant's financial crimes show that causing Eric Richens' death was her last resort, and this proves the identity and intent elements. The state asks that the court make intrinsic evidence findings on these 2 arguments and additional findings under Rule 404, as these additional arguments increase the probative, in the state's view, increase the probative value of the financial crimes evidence. Finally, Your Honor, regarding footnote 3 of the court's ruling, the state asks that the court note that the state advanced its complete the story argument in its moving papers before Blackwing issued, and then in its reply papers revised its argument to comport with Blackwing. Thank you, sir.
Yeah, let me be clear. Yeah. I understood your arguments. I just didn't find them persuasive. The state simply hasn't carried its burden to show a sufficient or persuasive basis that the arguments you just described satisfy the legal standard for intrinsic,
sure,
or provide a sufficient or persuasive basis to avoid the court's view of the balancing of the propensity inference that is most likely to be drawn under 404B, which implicates the 403 analysis the court made.
Your Honor, I appreciate that. And I don't think that comes through in the ruling. I think the ruling very clearly and specifically addresses the pecuniary gain. And the court, you know, may have built in its thinking as to the other 2 of the state's arguments, but I don't know that that is reflected in the ruling. And I think it would help if it was.
Okay, I understand your position.
Okay, thank you, sir.
Anything else on a preliminary basis?
No, Your Honor.
Okay, very good. Ms. Lewis, my apologies. No, it's okay. You can sit down. Oh, go ahead.
Your Honor, I did want to ask, can I move in and out of the courtroom as business requires?
Out of the well or out of the courtroom?
Both.
Yes, that's fine.
Thank you, sir.
Thank you. Ms. Lewis, we're here to talk about 3 experts. Happy to handle those in any particular order. Happy to have some legal argument and colloquy before or after taking testimony if necessary. What's your view of what the defense needs to do today?
Well, we're handling different experts, but if we could maybe handle Ms. Amon and Dr. Fox first, I think that if Ms. Amon were to testify and then Dr. Fox, and then we could handle that, and then Kathy, you're doing
The other two.
and then Ms. Nestor's doing the other 2, so I don't know if you prefer an order on those. So either order on the others.
And forgive me, with respect to Dr. Fox, nobody's challenged her.
No, she's going to testify if the court needs to hear it about the scientific reliability of the pathway to violence and why it should be excluded as under 702. Based on
So
her
let's
expert-
talk about that structurally. If I have one former FBI agent saying this is not the way we do it in the behavioral science realm, and I have another former FBI agent saying this is how we routinely do it in the behavioral science realm, doesn't that go to weight rather than admissibility?
Well, possibly, but I think it might be more extreme than that. And that's why I think it's important we hear their testimony. From my understanding, that the pathway to violence has not been used particularly in courtrooms and doesn't come anywhere close to meeting the reliability standard under 702. And Dr. Fox, formerly when she worked for the FBI, also worked in this area and has a lot of information about how that study was conducted. And it could be a balancing act, but I actually think it might be such a huge difference that it would go to admissibility and not wait.
Okay. I have some questions for the state on Ms. Amon first.
May I just briefly address the court?
Sure.
Then Ms. Sherbanek will address Amon.
Okay.
Your Honor, because it's the state's belief that the defense has not even met its minimal requirements under Rule 12.
To do what?
That they specify sufficient legal and factual grounds for the motion. Now, even assuming the court disagrees with that, the papers sufficiently address the threshold showing. As the court is well aware, after Ramash, after cases like Clopton and Gun Hill Dairy and the new Rule 702 flipped Ramash, which tended to keep a very narrow gate to allow very few witnesses through, it sort of flipped it upside down so it catches almost anything. And even if there's 2 witnesses who say the opposite thing, they can still come in under that new 702. And by virtue of the papers, the state believes it has met its burden of a threshold showing. Now, the court wishes to address specific issues. I just wanted to lay that groundwork. If the court has specific questions, we've got all our witnesses ready to go, as the court can tell. Mr. Throckmorton is here, and then the other 2 are on the line. So if the court wishes to proceed on to specific questions about Ms. Amon, then Ms. Sherbanek can address that.
I appreciate the argument. The defendant's initial briefing was certainly sufficient enough for the state to file an opposition brief that had legal analysis, citation to cases, and consideration of the specifics of each
Oh, thank you, Donnie.
So,
Thank you. I can't see in StreamYard, but who got it? It don't tell me who got it on StreamYard. Thank you, ma'am. She gifted 1 Crime Cafe membership. Hold on just a second. Let me give you some sparkle. Thank you, sweetheart. Mickey got it. That's hilarious. That's like twice now, I think, that somebody has gifted a membership and Mickey's got it. That's so funny. Yay, Mickey Joe. That's funny. That's cute. Hold on a second. I'm trying to do a little bit of a work here to that stuff everywhere. Okay, now I can lay that down. She got the last one. Okay, that's what it was. That's so funny. All right, here we go. I'm going to hit the play button.
the state's argument regarding the
Thank you, Donnie.
insufficiency
That's
of the
sweet.
defendant's initial briefing is respectfully rejected. I have specific questions regarding each witness. Within the framework that you described, 702, and then if we're past 702, we have to deal with Rule 403, maybe. Whose witness is Ms. Amon?
Ms.
Ms. Sherman, I
Sherman.
can ask you some questions.
Of course.
You just got to pull that mic closer to you. Okay. In its brief, in opposition to the defendant's motion to exclude Ms. Amon's testimony, on 2 occasions and in bold print, the state says Ms. Amon may become helpful to the jury. Under what set of twists and turns at trial do you see Ms. Amon testifying? Is it in the state's case in chief, or only potentially in the state's rebuttal case, depending on the arguments and other testimony that comes in from the defense case?
The latter, Your Honor. It would be part of our rebuttal case, depending on what potential theories, evidence, witnesses come in through defendant's presentation.
And one of the examples the state gave was, forgive me, that in the state's view, Ms. Amon's testimony may be helpful to the trier of fact to rebut an argument that, hey, this doesn't happen like this. This is not the way violence gets committed. Wives and mothers don't suddenly kill their husbands. And I understood the state to be saying, well, there's a progression here. People form this plan, unless it's the emotional pathway to violence. But this planned pathway to violence has a progression. It's been studied. This is how it works. Am I inferring the state's argument correctly?
In part,
Okay.
I think we don't know which theories, of course, defendant will put forth, but there are multiple theories that could come out at trial where Ms. Amon's testimony becomes relevant to assist the jury in placing the facts and evidence that they have heard into an analytical framework. And again, Ms. Amon's testimony, and I don't think this is clear from the defense's objection or from their reply, she is a blind expert. She
Right.
will not be saying Ms. Rich, and also from the declaration from Dr. Fox, they seem to all miss the point that Molly Amon will not be saying Ms. Richin fits this profile, therefore she committed murder.
Right.
That's not the testimony. That's not what we would elicit. We agree that would be improper, and that's not our intention with Ms. Amon's testimony. It's more to assist the jury in a framework to understand how targeted violence occurs. Again,
Sometimes, right?
well, yes, but also Ms. Amon could describe that in every targeted act of violence, and this is part of her proffer, that
What are you
there
doing,
is
Donnie?
a framework, a
What kind of experiment are you working on? Thank you for another one, ma'am. What are you trying to figure out? Who got it? Judy who? Judy what? What sort of experiment are you working on? Congratulations, Judy, on your gifted membership, and thank you again, Donnie, for the membership gift. I appreciate that a bunch. Judy. I want to know who gets them. I know it's random, just having fun. Yeah, it is random, and I know it's like sometimes it's in for people in the chat, it'll get it, and then other people's like it could be somebody that is like lurking that gets it. You know? Like I've heard people say before, oh yeah, gift memberships because it pulls the lurkers out. Judy. Oh, Crochet Queen. Hello. Crochet Queen. Welcome. I said that in my best Cary Grant voice. That's what I was experimenting. Oh, got you. Crochet Queen, do we know you by another name over here? Do we know you by another name? Just wondering. But welcome. Welcome. All right, I'm going to hit the play button again. Oh, okay. Mrs. King. There we go. Crochet Queen is also Miss King. There we go. You little sneaky sneakerson.
Pathway to violence that perpetrators of targeted violence follow. Now, do they complete a couple steps and pause? Do they all follow the same timeline? And
Sorry, I keep pausing. The same thing has happened to me, Morgana. I've gotten like a membership. Like I've gotten an email that'll say, congratulations, you were gifted a membership, blah, blah, blah. Right. And I'm like, but wait a minute. I haven't been on that channel in a while. Oh, look who it is. Speaking of lurkers, I'm here so I don't call you again during your live. Oh, gotcha. Miss Gracie Poo. She says, excuse me, ma'am, I'm not lurking per se. That's my girl. I've gotten gift memberships to Trial TV Live a couple times. Have you really? Nice. All right. What are you doing, Grace? I know you're on your way to work. Otherwise, my phone would be ringing. Did my phone ring? Let me go look. No. Okay. My phone didn't ring. Because I have it on Do Not Disturb. She's going to choke me. I wanted to try an experiment. I can't get gifted memberships under the other account. Oh, got you. And Crochet Queen, the reason is because that account is a branded account. I don't know how or why. There's no rhyme or reason. When you signed up, you probably didn't know you were signing up under a branded account. I don't know how that works. You've gotten memberships to your son's gaming channels? Oh my God. Crazy. Slapping makeup on because you're running late. Well, it is 2, 3, 4, 5, 6. It is 6:13 a.m. for you. 6:13 a.m. Right? You are running late. You're usually already in the car by now. Ma'am, what is wrong with you? Did you have a late night? Did you have a late night? Oh, yeah. That's exactly what happened. I can't hype channels either. I don't know what the hype thing is about. I don't know if my channel is hypeable. You know what I'm saying? I don't know that I have that feature. Like, I think that there is a super thanks feature on my channel, but I'm not positive. I think that there is because somebody did one and I can't remember who it was. But like the hyping, I don't even know what that means. I don't know what that means. Lives are not hot. You can't hype. Are you sure about that? Because I thought that I heard someone, another channel I watch, mention that for live streams, but I could be wrong. I don't know. Huh. All right. Well, we're going to hit the start button back on Corey Richins. And yeah, let's see what happens. Let's see what happens.
The exact same sequence, maybe not necessarily, but there is a framework of perpetrators of targeted violence who follow a pathway to the attack. And all of the targeted acts of violence that have been studied, the perpetrators follow this framework to some extent.
Okay. When you say all, you provoke some questions regarding the Diaz versus United States case that was cited in
Sure.
Defendant's brief. Now, in fairness, that case has a holding that goes the other way, right? That said the expert there said, most cases it works like this. Most people that are transporting drugs know they're doing it. And the United States, a majority of the United States Supreme Court said, that's fine under Rule 704B. That's not a implication regarding the defendant's mental state or what was in their mind, because it's most, not all. And is Ms. Amon in that bucket of blind experts, or is she going to say, no, this is how it works every time?
I think we would have to ask her that direct question. I mean, and she can explain to the court what her answer to that is and why. But I think to say all the time, always, is extreme. I don't think that's what Ms. Amon's testimony would be, but I would rather not speak for her. If that is in fact what her testimony would be, then we need to address that and explore it. But again, when we're talking about a retrospective analysis, which is part of what she's talking about in the studies of the pathway to violence, they know that these perpetrators have committed the ultimate act, right? They have perpetrated their attack. So that is a different analysis than to say, are there other folks who have started on the pathway to violence and not made it to the ultimate act, to the attack phase, if you will? Yes, those people exist. And Ms. Amon would not know who those people are.
I read her proper. She seems to explicitly acknowledge that people stop at various points
Right.
along the pathway.
That's my point. So
Okay.
to say that if you start on this pathway to violence, you ultimately will commit an attack regardless, all the time, always. No, that's not her testimony.
Okay.
And that's not factual. But for her to say in all of these multitudes, decades of studies of people who have committed a targeted act of violence, we know the end result. The attack has occurred. We can place those folks on a pathway to violence. We can put them on these steps and identify the steps that they took to that attack.
Okay. All right. Hold on a second, Ms. Lewis. Anything else you wanted to say at this point, Ms. Sugar?
Not unless the court has additional questions on that point.
No, I understand the state's position. Ms. Lewis.
Well, Your Honor, listening to this, it might actually make more sense for Dr. Fox to go first. I understand the threshold is low. However, under Rule 702, the argument here is this is not generally accepted in the relevant expert community.
Doesn't need to be, though. That's one of two ways to survive 702B. If it's based upon a scientific method or sufficient education, training, and experience that's reliably applied to sufficient facts and data. But as a blind expert, she doesn't need to apply it at all.
I disagree. There's a case, first of all, yeah, the argument is that under 702. There's a case that is out of the Ninth Circuit that is directly on point and
Is it cited in your brief?
no, because I didn't know about it.
Okay,
That's
can
something
you give
I
it to me?
just discovered.
That's okay.
Anyway, it is United States versus Wells. Let me give you the site. 879 F3rd 900. And that case was also a blind expert who is actually one of Ms. Amon's colleagues in writing the profile for violence. And his name is Dr. I don't know if it's Dr. Reed Malloy is the name of the expert, J.R. Malloy. And there's also, and yeah, I'm sorry, I actually just found this case yesterday. But there's also a 403 and 404B argument because the way this works in courts when they admit profile testimony, which the Ninth Circuit reversed and said this testimony comes in only very, very limited circumstances. They talk about how it's typically used in drug courier cases. This was a case, a homicide case, where Dr. Malloy was using the precursor to the profile for violence. It has very much the same criteria. It has been modified since then. This was in 2017. And he did a profile of killings in the workplace. He was a blind expert, although he admitted on the stand that he had reviewed the case at hand, although he didn't testify. He testified as a blind expert, although he admitted he had reviewed the case and the defendant. And the court ruled that this is improper character evidence, among other problems, because what happens is the profiler testifies that, so people who commit, in this case, workplace murder, have characteristics X, Y, and Z. And then other witnesses get on and say, well, the defendant had characteristic X, Y, and Z. So therefore, in conformity with that character, he committed the murder.
Yeah, but this is different than that. Like, I've looked at Ms. Amon's proffer. She doesn't make it that specific. I'm sensitive to that concern. And certainly if she was saying, when we look at domestic violence, homicides, what we see are the following characteristics almost universally. She doesn't do anything like that. There's no level of that kind of specificity. She talks more high level in terms of initial grievance, inability to let it go, form of a plan. I may be missummarizing here, but there's a higher level to it. And when we look at Diaz is even more specific, and somehow a majority of the United States Supreme Court is like, yeah, they said most, not all. So the trier of fact can draw distinctions. How do I apply Diaz to Ms. Amon's testimony to say she can't come in?
I haven't looked at Diaz in a while. I'm sorry.
That is one you cited.
I know it is, and I did not reread that case. So I would actually.
We can,
What? How are you going to quote it, cite it, and then not know it? She sat down. She sat down. She should have sat down, all the way down. She should have took all the seats. She was embarrassed by that statement.
we'll take a break at some point.
Need
We
a
can
moment to
compare.
review that to be right.
Need a moment to review
okay.
what you cited.
Ms.
Okay.
Renek.
Oh, I'm sorry.
Oh, okay. Yeah.
Just to, I do think that it would be helpful to hear Dr. Fox's
Sure.
testimony. For one thing, this routinely isn't used. It's used at NBAU as an investigative technique sometimes,
Right.
but it's not used in the courtroom. And that's because of all these problems that Dr. Fox is much more qualified to address than I am in terms of it's junk science is what it is. It's not scientific. It's not used in the community. And I think that does stop it even under our low threshold here.
Well, hold on, but come back to the specific context of this case. The state has noticed Ms. Amon as a potential rebuttal expert, if necessary, to respond to an argument from a defense witness to the effect of, this is not the way it works. This allegation that Corey Richens killed her husband is not credible because wives don't kill their husbands. People don't just snap and do this. That would seem to make this kind of explanation of how violent crimes are planned and executed helpful to the trier of fact under 702A to say, well, actually, based upon a retrospective study by the FBI Behavioral Science Unit, there is a pathway in which people do this. Full stop. And then the trier of fact can say this is within or without that body of cases. Tell me why that isn't allowable under Utah's Rule 702.
Well,
Now, first of all, if the defense doesn't make such an argument, then the state never calls Ms. Amon.
I think we're going to need some clarification beforehand. If Ms. Richens testifies and testifies that she did not do this,
That denies committing the crime.
denies committing the crime, then how does that not open the door for them to say, well, of course she committed the crime because she's on this pathway to violence?
No, I don't think they get to do that. That would be more like profiling.
Okay. I still have the whole 702 problem no matter how. And this is the first I've heard it's only going to be used in rebuttal. I think we would actually use less time if we let Dr. Fox
Happy to.
go through and explain the problems with the reliability of the science and then go from there, if that's all right.
Sure. Ms. Sherman.
The only points I wanted to make, and the court has honed in on this, but in Dr. Fox's declaration that was submitted as an attachment, she analyzes the federal rule 702 and why Ms. Amon's proffer does not fit within that. There are fundamental differences between the federal rule and the Utah rule, and I don't believe that it's helpful for the defense's witness to make a legal analysis about whether Ms. Amon's testimony does or does not comport with Rule 702. That is for the court to do. So
I agree, but I can sort that out.
And Dr. Fox is familiar with the Utah Rule 702 and is prepared to address that.
Well, yeah, but I don't need her to address the law at all. I just need her to tell me her view.
I understand,
of
but she hasn't now analyzed it under the Utah
Okay.
law. All right. Would it be all right if we go forward with Dr. Fox?
Sure.
All right.
Dr. Fox, good morning.
Hi, good morning.
Okay. Sounds like you can hear us okay.
I can.
Let me turn on the video in the courtroom so that you can see Ms. Lewis.
Good morning, Dr. Fox.
Hi, Ms. Lewis.
So can you just please state your name for the record and tell us what your current position is?
My name is Dr. Brianna Fox. I'm a tenured full professor in the Department of Criminology at the University of South Florida. I also hold courtesy appointments at the Department of Psychology and Mental Health Law and Policy, both at USF. I'm a faculty affiliate in the Mental Health Institute at USF, and I'm also the co-founder of the USF Center for Justice Research and Policy.
Thank you. And could you, did you want to swear her in? We didn't do that.
Yes, thank you.
Thank
Dr. Fox, would you please raise your right hand for me? Do you swear that the testimony you'll give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right, please proceed.
All right. And could you briefly describe your educational background for the court?
Yeah, well, I went to Penn State University. I dual majored in psychology and criminology. I was going to be a pre-law, but I actually changed tacks. I went to the University of Florida to earn my master's. And then I earned my PhD instead of my JD from the University of Cambridge in England. My doctoral dissertation specifically evaluated the accuracy and reliability of offender profiling methods, which is obviously related to the issues before this court.
Thank you. And what's your experience with the FBI?
Well, I was an honors intern. That's how I started. I went on to get a position. They asked me to join them in the behavioral science unit as a research fellow. They were actually acutely aware of the problems that they were facing with threat assessment and how inaccurate it is. So that's actually why they brought me on, was to really bring that into the modern era, improve it, use statistics and science, which they were sorely lacking. So that's how I got my start. I worked in the behavioral science unit as a research fellow. I was doing research. I was going over to the BAU. I was training people like Ms. Ammon, although I didn't actually work with her specifically, and trying to get them kind of brought up to modern standards. Then I got a position as an FBI special agent. I worked in the Las Vegas division. And in between there, I worked with the Tampa field office in the field of investigations group. I actually still work with the FBI. I just did a project with them out in Sacramento.
Let me ask you just briefly. You talked about that you worked with the BSU, and I know Ms. Ammon has talked about the BAU. What's the difference between those two divisions?
Yeah, the BSU was really their research arm. That was where they were really tasked with doing the data analysis, trying to develop the new, latest, and best approaches for investigative techniques. We would then go on to train both people at the National Academy. That's a prestigious group of law enforcement that come in from around the globe. We would train them, so our methods would get disseminated into their investigations around the planet. But then we would also go to BAU. We would take what we were doing, implement it. We were also trying to train them to bring them kind of up to what we were doing over in the research arm. BAU was very operational. We were the research folks.
Okay. And have you published research relevant to offender profiling and violence risk?
Yeah, that's actually the main part of my job. I have more than 50 peer-reviewed articles. I've written 5 books. I have over 3,000 citations. My work has been published in the top journals in psychology, clinical psychology, law, sociology, criminology, developmental psychology. So my goal is to actually try to create more established and evidence-based risk factors, trying to understand the development of offending. Again, this is an area that we are really lacking in, so there's plenty of opportunity for that science and data-driven research.
Okay. And do you have experience in violence risk assessment or threat assessment?
Yes, I do. I have extensive experience in both violence risk assessment and threat assessment in my academic research. Obviously, I also get federal grants. I work a lot with the U.S. National Institute of Justice. I have applied professional experience working with law enforcement agencies. This was mentioned before this, but there is a distinction between investigative efforts and then obviously applied efforts in a legal setting. I would say that my experience as a FBI special agent and of course as a research fellow in the FBI's behavioral science unit, where I evaluated and then try to help improve the scientific validity of both profiling and threat indicators, is what really motivated me as a researcher, kind of trying to take that old school approach and modernize it, and really trying to assess the reliability and validity of violence risk assessments, as well as these theories of behavior. That's where I won the early career award in specifically my work on developing theory on why people become offenders.
All right. And you heard us talk in court about the different standards and rules. And have you familiarized yourself with the Utah standard in addition to the federal standard?
Yes, I have read about the Utah Rule of Evidence 702. I have testified as an expert in other cases, so I'm familiar with the federal rules of evidence. And I do understand as well just how to evaluate scientific merit and reliability. I was the editor of our field's premier journal, Justice Quarterly. So as a journal editor, it was my literal task to assess scientific merit and how we can really understand, is this a credible theory? Not every theory gets published just because it is a theory. It really has to meet certain standards.
Is there any objection to certifying that she is an expert in this particular area?
Nobody said she isn't.
Okay, just wanted to make sure as we move forward. All right, so are you familiar with the Pathway to Violence model?
Yes, I am.
And can you describe what that model proposes, just generally?
Yeah, so the Pathway to Violence model is a group-based descriptive framework. It outlines a sequence or phases of behaviors that are thought of being observed retrospectively among individuals. It's really applied almost exclusively to individuals that commit targeted acts of violence like mass shootings or terrorist attacks. To be clear, it is not a diagnostic tool. It is not a validated risk assessment tool, and it cannot be applied to individual cases. It was not created using data. It has no scientific testing or reliability. It is pure theory, and it was postulated by individuals that, frankly, I don't want this to sound mean, but they have no scientific training.
Right. And is it designed to diagnose or predict whether a specific individual will commit violence?
Again, no. It's a subjective, group-based descriptive framework. At best, it applies only to some cases. I thought the judge's explanation of it was great. It applies sometimes, but in other cases, it doesn't apply. So we really have no idea how often that occurs. It applies sometimes, except for when it doesn't. So it's completely disconnected from data and science.
What's the difference between a descriptive model and a predictive risk assessment?
Well, group-based descriptive models just summarize patterns or characteristics that are observed across groups of people on the average after the events have occurred. That's ones that are created using data. The ones that I'm familiar with, like when I worked in the FBI's behavioral science unit, the infamous, organized, disorganized profiles, they were created just like by thinking about what we see sometimes in cases, and sometimes we don't. Those have also been excluded as being admissible for that same reason. That doesn't mean that you can't use them if you want to investigatively, but you can't use that later on in court to say, this person fits this profile. So predictive risk assessments, by contrast, are empirically tested. You want to be able to forecast individual outcomes before they occur. And just, a distinction from the group-based descriptive method, you really have no idea how often it applies or doesn't. Unless there's associated data, you really have no clue how often is it accurate. You can use the words mostly, but it's one person's opinion. There hasn't been a scientific evaluation of this to actually say this often it applies, this often it doesn't. There's no known error rate. There's no accuracy rate. There's no reliability measure. It's just a, guess.
So that's why it's important in a legal framework that the Pathway to Violence is descriptive framework and not predictive.
Yeah, it's descriptive. It would be like saying that both of us are female, and females are more prone to, I'm trying to even think of an example that wouldn't, that would be kind of as like detached from the data. But we could say, well, both these women would, engage in, they're both in a courtroom today, so women tend to be in courtrooms. It's like, well, just because the two, people that, our judges seen today, both are in a courtroom, that doesn't mean all women are in a courtroom. The example I use in my undergraduate course, every person who went to the moon eats chicken. That doesn't mean that everyone eats chicken goes to the moon.
All right. So does the Pathway to Violence, does it tell us how likely it is that someone will engage in violence?
No, that's a major flaw of it. It has no estimates for the likelihood, probability, risk. It doesn't quantify anything. There's no statistical basis behind it. There's no prospective testing, no base rate adjustment, no error rate. All the reliability measures that we would see as scientists, it has none of those.
And can it distinguish between people who commit violence and those who don't commit violence?
No, I think the major, I keep on saying this, another major problem I have with this is there are lots of people that have those grievances. I can name like so many cases off the top of my head that will never go on to commit violence. And we have no idea how often people will follow this pathway and literally never commit violence, or they do some things and then stop and don't commit violence. There's no associated numbers with these. So people who engage in, out of a larger group and engage in similar grievances, thoughts, and behaviors and never engage in violence, we are unaware of. What the Pathway to Violence model is doing, they're selecting on the dependent variable. They're selecting people that commit violence and say, oh, all those people do this based on, our thoughts. It's not even based on their analysis of data.
All right. So addressing the reliability and the 702 standards, has the Pathway to Violence been published in peer-reviewed journals?
No, I was actually shocked. I thought I heard somebody say that before this. I trust when I say I have researched this extensively. Book chapters and governmental white papers are not publications. Those are, they don't undergo a peer review process. I've written 5 books, so I am aware of the process. It's not that. I've also written governmental white papers. There's no peer review process. You can write whatever you want as long as the publisher agrees to print it. You're good to go. In Ms. Amon's proffer, the Pathway to Violence model was just discussed only one time in a published paper in the Journal of Forensic Sciences. Again, I don't know how to say this without sounding like I'm mean, but that's a predatory journal. They write to me often and ask me if they can publish whatever I want in that journal. It's not like a legitimate, valid journal. That paper that was published in the Journal of Forensic Sciences, it wasn't even about the Pathway to Violence model. It was about political assassination in the United States. The Pathway to Violence model was only mentioned. It wasn't even a study of the Pathway to Violence model. So it's never been published in a peer-reviewed journal ever to date. And I think that's saying a lot.
When discussing reliability, why is it important? I asked this, I've had battles on this before with experts, but why is it important that it be published in peer review journals as opposed to other journals or just being available?
Yeah, it's not so high of a standard, but that's a standard for a scientific merit and reliability. We don't give things that stamp of approval if it's not reliable and valid. That's not the highest bar in the world. So to say it was never published in a peer-reviewed journal, I really think that's saying a lot.
Okay. Does the Pathway to Violence have a standardized methodology?
No, and that's actually one of the reasons why it hasn't been published, I would assume, as a journal editor. There's no operating manual. Everybody can, what I determine to be a grievance could be different than what Ms. Amon thinks is a grievance or what you think is a grievance. There's no coding sheets. There's no requirement for evaluators to determine these things using the same criteria. There's no uniform objectivity in this. Everybody can look at it and say, that fits, and there's subjective interpretation behind it, meaning evaluators are not constrained to apply the term the same way across different cases.
All right. So different evaluators could look at the exact same fact pattern and come up with opposite conclusions. Is that fair?
Yes, absolutely, because there is no standardized criteria for what these things mean. They're barely even defined because again, there's so little peer-reviewed papers even discussing it, let alone zero on it. They don't even invoke it in peer-reviewed publications. It's sort of constrained to these side areas. So an example of this would be 2 evaluators could use the Pathway to Violence model and can reach opposite conclusions, and there's no way to determine who's correct.
Okay. So is that consistent with things that are admitted as being scientifically reliable?
No, I think it's actually the opposite. Reliability at its core means, the example again I use in my undergraduate course is, if you have 2 people stand on 2 scales, you would expect that the scales say the same number. That's reliable. If we have somebody stand on 2 scales at my gym and at my doctor's office, and there's 2 different results, it's literally not reliable. That's the definition of reliability. Or if you stand on the same scale every day and all of a sudden you're getting different results, it could mean that your weight has changed. But if it's 2 times in the same day, probably not. It means your scale is broken. So, this model is broken.
Okay. Is that connected to inter-rater reliability? I know we had discussed that, and I wasn't entirely clear myself on how that is relevant to the acceptable.
Yeah, inter-rater reliability is, again, since reliability is such a key foundational element of what is scientifically valid, interrelated reliability is basically this idea that if 2 people use the same construct, will they get the same result? And if people are having the same scale, implementing it and get different answers, it's not reliable. It just has a basic foundational level. So you would want the same instrument applied and to get similar results. So two people should be able to look at the same case and have a general agreement that this, person either meets these criteria, they would agree they're both experiencing a grievance. That's something that you would expect in a rate of reliability. That's mandated for something to be considered reliable. I would actually argue that this doesn't even have the ability to determine if it's reliable, since there's been no study conducted ever on the inter-rate of reliability on the pathway to violence model.
Does it have a known error rate?
No. And that's obviously a problem in terms of false positives. You could say, I think this person, or this is what tends to occur on the majority, that somebody would be on this pathway to violence. You have no idea how often that happens. You have no idea how often you're wrong. You could say that is the case, but we have no idea what percentile of the population actually fits that model, because there is no known error rate.
And why is that a problem for in terms of admissibility?
Yeah, well, without an error rate, the court cannot assess reliability. A method that you can't quantify how often it's wrong if you literally don't have that number. And this has never been studied. It has no data behind it, so you have no idea how often it's incorrect.
Okay, and has the model ever been applied prospectively to identify individuals then who later actually do go on and commit violence?
Never.
All right. Is there any scientific data showing how often? I'm almost done, but I'm sorry, what?
Oh, I didn't say anything. My apologies.
Oh, okay. Is there any scientific data showing how often people identified as being on the pathway then actually never do commit violence?
No, and without overemphasizing this, there is no reliable data on this. And I'm emphasizing it because that was why I was brought into the behavioral science unit. I was the first and only person at the FBI to do research on mass shooters and terrorists on the pathway to violence. It was literally the task I had. I was the person who did it. And this was in 2000. The first time I started on it was 2010. And then the process of getting access to data was, as you can imagine, quite difficult. I was going through all of it. I was trying to code it. I was the first person to do it. No one had done it before. There was no study ever on this. And what I'd been finding, I didn't have the resources to really complete this in the way it should have been done. And it was never published. So that's why I'm also quite sure there's no publications on it. But it really was so much more complicated than what the pathway to violence model suggests. That's such an oversimplification, and it's so inapplicable in so many circumstances. And like I said, there's no known error rate. So we know it's wrong, we just don't know how wrong it is.
So what data was it developed from, the model?
The pathway to violence model, or what I was doing?
The pathway to violence model.
Oh, it's not based on any data. It's based on, I teach a forensic psychology course, and so there's a great line. I really respect the original profilers. What they did was, groundbreaking back in the 1970s, right? But obviously a lot has happened since 1977. What we've expected, in court, DNA, our standards for what we admit into court has changed a lot. But back then, 1977, when they were developing this, that was what they thought was best. And they developed it off of what they called intuition, educated guesswork, and hunches. And so I always teach my students, that was the 70s way, but we're doing this differently now. And the pathways to violence model was developed in that same approach. Educated guesses.
Okay. So Ms. Amon, and I suppose others who've worked on the model, believe that it can be applied after an offense has occurred. And is it scientifically valid after offense has occurred to then go back and use the pathway of violence model?
No, that's like a basic logical fallacy. That was probably on your LSAT exam, that you can't do that. Applying a descriptive model retrospectively to infer that the person therefore fits it is like predicting the lottery numbers after the drawing already occurred. I don't know. I don't know how to describe this another way. It just doesn't make logical sense. It is a logical fallacy to do so.
Well, in fact, an example of that fallacy is the 9/11 attacks. Is that right?
Yes, that actually, there were, there's the pathways to radicalization. We've, toyed around with this idea. They've all been kicked around and kicked down. But that one was the pathways to radicalization profile. And it was this like traits shared by attackers. They're young, male, Middle Eastern, and you could say looking at, the 9/11 attacks, yeah, they all fit that profile. But when you apply it retrospectively, there's 55 million, right, plus people that fit that are young Middle Eastern males. Like literally it goes down from, everybody who, commits terrorist attacks fit this profile to 0.00000, like I don't even know how many digits out, 0%. It's basically 0%. It doesn't fit at all. There's no validity. There's so many people that fit that profile and never go on to commit a terrorist attack. So what's the actual value of saying this is a pathway to radicalization? There's so many people that would fit that and never go on to commit the act. Cherry picking after the fact and saying, all the people fit that. Not only is that a logical fallacy, I would actually say that's, it could be a violation of people's rights, to be able to make that implication of them just without even having 1% accuracy rate.
So how does that relate to the pathway to violence model?
The pathway to violence suffers the same fatal flaw. By implying these group level descriptives, you're first of all applying it, and we have no idea. It could apply to 1% of people that have a grievance. They, go to a workplace nowadays, right? So many people have grievances. So many people are upset. They're feeling stressed by the economy, by their situation. They even may say, "I'm so stressed, I'm mad." They will never go on to commit violence. This is an extremely rare base rate event. And low base rate events have very high risk of false positives. And when you are now going to take that and enter it in as an expert opinion, obviously, just me as a scientist, as somebody who supports the research in this area, and of course, like as an American taxpayer, I feel very concerned by that.
So let me ask you, you heard the discussion before you testified about if Ms. Amon were to testify in rebuttal, that why someone who is a mother or someone who is in the position of Ms. Richins might commit this offense because of being on this pathway to violence. In your expert opinion, is that helpful to a jury, and why is that problematic?
Yeah, I actually think that the risks are so far beyond the benefits. I mean, there's so many people that experience grievances, anger, even violent ideations. There are a lot of studies on that. So there's plenty of research that can be discussed to talk about the base rate of those. They're high, but then when you look at the predictive ability, how often do they go on to predict violence? Extremely low. The reason is because, if we were that good at predicting violence, I mean, think about the problems we have when we're talking about parole. We're talking about, risk assessment, when we're looking at releasing people. We're doing, my big NIJ grant was specifically to do risk assessment to try to identify people who are low, medium, and high risk. This is such a big area because we are so bad at it, even with huge amounts of data, huge amounts of research behind us. There's no way that something like this is able to be better than all of the research and data that we have based on hunches. Our data suggests that things like grievances, feeling anger, violent ideation, they have such a low predictive ability to actually accurately predict violent behavior, because violence is a low base rate phenomenon. Lots of people have these types of feelings. Very few ever go on to commit violence. Even if you fit all of them, you literally have a low probability of actually committing violence. I could actually, look that up in a couple of minutes and tell you what the base rate is. But because this pathway to violence model has never been evaluated, anyone who would say, here's what I think, they're just guessing on how often someone would actually go on to commit violence.
Let me ask you, tell me if I'm wrong. When I was looking at the pathway to violence, it appeared that the purpose of it was to try and help identify mass shooters, school shooters. Why has this been put together? For what purpose, if it doesn't actually ever predict who will go forward to commit a violent act?
I'm telling you guys, if we were able to predict with any level of accuracy who was going to become a school shooter or a mass shooter, I mean, we would have a much better situation in our world right now. Again, even with accurate data, like we're collecting, looking at this, putting very sophisticated predictive models together, we are so unable to predict violence, school violence, these targeted violence offenses, and domestic violence is even harder to predict. As our judge mentioned earlier, the vast majority of them are emotional. They're not these, long premeditated, thought out things. So the emotional dynamic factors actually have a much higher predictive validity than any type of long-term grievance, at least based on research. If we were able to do this, I would feel much better about my young son, going to school soon. I'm terrified because we are so bad at it. Even from a magnet, huge amounts of money being spent on this type of research, we are still unable to do it with any type of reasonable accuracy, because finding that needle in a haystack, someone who meets all of these criteria but is actually going to commit violence, is so hard to do.
Let me ask you, just for sake of argument, if we were to assume that the pathway for violence had some reliability in the area of mass shooting and school shooting, was it meant to be applied in this sort of case?
Oh, no. And that's actually, again, something I talk about in my undergraduate courses. We have this problem, it's like mission creep. We think, because it applies here, it can apply over here. And that's absolutely not the case. A domestic violence type of scenario, poisoning, they're so fundamentally different in the way those two things are committed, played out. Applying something that is, even without data, created for the purposes of these targeted attacks that do engage in more radicalization behaviors. You applying that to something that's statistically more emotionally driven, that would be very inappropriate.
All right. So just to wrap up, in your expert opinion, should the pathway to violence be admitted as scientifically reliable evidence that a jury can rely on?
No, absolutely not. If we're basing this on reliability, if we're basing it on, how using it to know that this is scientifically valid, it absolutely not. The logical fallacies that are endemic to this, the huge amounts of unknowns, like how often it's wrong, which would be far more wrong than right. It's akin to like the Barnum effect at circuses, or like psychics. That would be the closest, I would say, in terms of how accurate and valid and applicable this would be to an individual case.
I have nothing further.
Ms. Shervnak, do you have any questions for Ms. Fox?
I do.
Ms. Fox, may I ask you just a couple of basic questions?
Surely.
You went through the FBI Academy at Quantico.
Yes, I did.
Were the pathways to violence taught as part of that curriculum?
No, it wasn't.
Did you have exposure to this during your career in the FBI?
No, I wasn't. There are these, similar models, like, I think they call it like pathways to radicalization. And I just learned about that. And again, like while I was in the BSU, that was one of the things that I was brought on to try to revamp and improve.
Okay, thank you. Ms. Lewis, anything further?
No, Your Honor.
Okay. Ms. Shervnak, anything for Dr. Fox? Okay. Thank you, Dr. Fox. You're welcome to stay connected, but you're also welcome to turn off your video and audio.
Thank you.
Ms. Lewis, do you want to ask any questions of Ms. Amon?
Are you not going to put Ms. Amon? Is the state going to put Ms. Amon on, or only if I have questions, I guess would be
Ms. Shervnak, are you relying on her proffer, or do you want to elicit some testimony from her?
I'll elicit some testimony from
Okay. Ms. Amon, do you mind turning on your video and audio? May I swear you in, please? Do you swear that the testimony you give today will be the truth, the whole truth, and nothing but the truth under the pains and penalties of perjury?
I do.
All right.
Good morning, Ms. Salmon. Good morning.
Your Honor, before I begin with her testimony, Ms. Amon's CV lays out her qualifications. The state's position is that she possesses the requisite knowledge, training, experience, education to satisfy 702A. If the court sees it differently, I'm happy to ask her some of those questions, but I prefer to focus my questions directly elsewhere. If that
I
makes sense.
agree that her CV reflects that she has sufficient education, training, and experience to qualify under 702A as an expert in her field.
Thank you, Your Honor. So, Ms. Amon, I don't think we need to go through all of the steps of the pathway to violence. I think the court has the generalized view of it, but what I would like to ask you are a few questions about how this model was developed, and we'll start there.
Sure. So in terms of how the model was developed, you'd have to, I guess, go back. The scientific research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. It's affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound, and the cats would inch forward, and they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And
Okay, what is she laughing at? Is she laughing about the woman talking about this cat, whatever arousal stuff? I don't know what she's laughing at. I'm gonna have to rewind it. And also, why does the guy directly behind her look like Blake Shelton right now? I always notice the funniest things. He literally looks just like Blake Shelton sitting right behind Corey Richins. Just me? Anybody else see it? Why is she laughing? Let me rewind it.
Research leading up to where we are now started about 100 years ago, give or take, when researchers began studying aggression in mammals. Specifically, cats were the sort of the origin story of this line of research. And researchers noticed two distinct patterns of aggression in cats, depending on the circumstances. In some studies, cats were presented with a threatening stimulus, a very threatening stimulus. And in those cases, they demonstrated intense autonomic arousal. So arched back, fluffed tail, hair along the midline, standing on end, that's called piloerection, pinned back ears. They vocalized, such as hissing and growling, fangs out, claws bared, the whole show. You can sort of think of it as that classic Halloween decoration of the scaredy cat with the arched back and all that. And they very quickly lashed out with an emotionally charged and relatively uncontrolled attack with paws and claws. And that was labeled affective violence. It's affective for the psychological term affect, meaning sort of the state of thinking or emoting or feeling emotions. And then in other studies, the cats were presented with prey, like a mouse. And that was a totally different story. The cats were low to the ground, completely silent. Ears, instead of pinned back, they were open to localize sound, and the cats would inch forward, and they appeared to be planning and carrying out an attack at the moment of their choosing, typically with a bite to the neck or head, a very efficient biting attack that ended the fight really before it began. And over the next several decades, that line of research expanded to other mammals, including humans. And what they discovered was that not only do these behavioral patterns hold true in humans, but they're also biologically distinct from one another. And the understanding came now that affective violence, so that reactive attack, is triggered by lower brain structures in the limbic system, triggering an intense autonomic arousal, as I've discussed, usually accompanied by intense fear or anger, and a cascade of hormones, all culminating in a sudden physical defense against imminent threat, which could be real or perceived. It could be an internalized threat. And the evolutionary basis for that in humans is survival. So if you were an early human out on the savannah, there was really no time to ponder whether that movement in the bush was caused by the wind or a predator. The early humans who acted quickly were the ones who survived. In terms of predatory violence, we now understand that to be characterized by a lack of autonomic arousal or emotional experience and no perception of a threat. And that lack of stimulation allows for higher cortical activity in the brain to choreograph an attack that meets the attacker's goals, whatever those goals may be. And the evolutionary basis for that in humans is hunting for food. So early humans on the savannah who hunted with minimal autonomic arousal, no anger or fear, were better able to engage higher brain functions to plan and prepare in advance, and therefore were likely to return with food for their offspring. Those who could not or did not do that were less likely to survive and pass on their genes. And we know that humans, like none of us would be here right now if our ancestors didn't have the capacity for both of those types of violence. So fast forward to now, there have been studies on neurochemicals and hormones, neuroanatomical brain scans with PET and MRI, to look at the differences between these two modes of violence, and all of them support the bimodal nature of violence. So that research evolved more or less concurrently with behavioral studies that were going on in the 80s and 90s on attacks against celebrities, judges, governmental figures, and some others, all of which led to a very clear conclusion that intended violence is a process composed of discrete, sequential, and recognizable behaviors. And the pathway to violence model came into being at the conclusion of that time frame based on the biological data and the behavioral observation data from all of the studies, many studies. So that's kind of a 10,000 foot view of the science in terms of how we got to where we are now.
So how is the pathway to violence used in the behavioral analysis community?
We use it not to predict, but to prevent. And that's a very clear distinction that needs to be made. Prediction is not possible. We don't talk about predicting human behavior. We talk about preventing it. I would liken it to if, let's say, I'm your cardiologist and you came to me and you were very overweight, sedentary, hypertensive, you had high serum cholesterol, you had bacon for every meal, and you were super stressed out. As your cardiologist, I couldn't tell you that you're going to have a heart attack next Tuesday morning at 9:24 a.m. But what I can tell you is that you're at heightened risk for a cardiac event, and we need to manage your condition with lifestyle changes and probably some medication to lower that risk. That's how we work in behavioral threat assessment, and the pathway is part of that. It's only applied in cases where where someone has already presented themselves to authorities, to whoever, as raising concerns for violence. So the person is doing something that has brought concerns of violence to the table. Whoever's bringing us the case, maybe it's a school district, maybe it's a workplace, isn't sure what to do, we would begin to look at the behaviors the person is demonstrating, and our being on the lookout for possible pathway behaviors is one of the things that we would do. It's actually considered one of a court one of 8 proximal warning behaviors that we would look at to decide if this person needs a deeper look. So it's a tool. It's one of many tools we use. It's certainly been subject of many studies in terms of whether or not it's valid for measuring what we want to measure. That is behaviors that raise for us concern about whether or not violence might be on the horizon.
And is the pathway to violence utilized, or could it be utilized in instances of targeted violence that only include one individual as the target?
Oh, certainly. Targeted violence is targeted violence. They all share behavioral commonalities, particularly where the pathway is concerned. If you understand the nature of the items on the pathway, then you also understand that the majority of them are steps that most targeted violence offenders would pass through. Whether you're planning to kill 100 people or one person, you still have to make the decision to do it. You still have to engage in some planning, some preparation, even if it's very, very simple. Some people require a lot of planning and preparation. Some people require very little to get to a state of readiness. But it doesn't really matter what the size of the targeting is. That's not relevant. What's relevant is that certain behaviors must occur in most cases in order to get someone to a state of readiness to engage in planned violence. I'm not talking about unplanned violence or affective violence. That's not really relevant here. But most people will have to pass through some of those stages, if not all.
Is the pathway to violence model generally accepted in the behavioral analysis or behavioral science community?
Absolutely. It's completely foundational to what we do. I know of no learned and credible threat assessment professionals who don't believe in the pathway. It's at the foundation of what we do. It's included in virtually every aspect of what we consider the body of knowledge in behavioral threat assessment, which I used to administer. I'm a former chair of this national certification program in this discipline, and the pathway is very foundational.
And is that something that you would describe as currently used, or is this a past a model that was used in the past, or is it a currently used model?
Currently used. Up until about 2012 or so, it was kind of it was the name of the game. It was the pathway. And then right around 2012, we had the realization that it's but one of 8 proximal warning behaviors, proximal meaning close in time to potential act of violence. And so now we tend to look at pathway as one of those 8. So in terms of more recent studies, in terms of its validation, it's the proximal warning behaviors that we look at. We don't usually use the word pathway necessarily on its own, but it is a discrete behavior as part of the 8 proximal warning behaviors. But it's absolutely used now. It's very, very important to what we do.
And now, if you could explain the retrospective analysis and why prospective analysis is not feasible.
Sure. All the studies on pathway and proximal warning behaviors are retrospective. In fact, someone asked me at a conference the other day, where are we on prospective research? And my answer was nowhere. We can't do it. So retrospective analysis is looking backward at cases with a known result, so violence. So let's say I want to look at a single person homicide in a workplace. I would look backwards at the completed event, knowing that it had the result that I'm interested in, violence. And then I would look for what patterns of behavior can I identify that did occur leading up to the violent event, and then code those. And so I would know that those occurred. So a retrospective study would have a sample of cases and then look backward in time and code the behaviors that we know to have occurred. And that helps us to understand what are the commonalities. You can't, Dr. Fox is absolutely correct that those studies can't be used for prediction. They're not predictive validity studies, but what they do is validate the measure as measuring what we intended to measure. Prospective is, you would need a prospective study to truly call something predictive, but to do a prospective study in violence would be to have a case of concern, and then look for what you believe to be pathway behaviors. And once you've identified them, it would require you to sit back and do nothing and allow violence to unfold and then code your data, which is horrible to even think about. None of us would ever do that. So we use retrospective analysis, and it's widely acceptable in the behavioral sciences as a research strategy.
Thank you. Just a moment. Those are my questions for you at the moment. Thank you, Ms. Ingham.
Just a moment. Good morning, Ms. Amon.
Good morning.
So, Ms. Shermanek asked you how the model was developed, and you told us about cat research, but I didn't hear an answer as to how the model was actually developed.
Sure. So in the 80s or 90s, a number of studies were conducted on attacks against public figures, political figures, judges, other people, and in those studies, it became quite clear that the offenders were typically engaging in a sequential and recognizable cascade of behaviors leading to the violent attack. And so that became the pathway to violence. The data collected from those studies showed that 6 particular discrete stages were happening in virtually every case that was studied back at that time. And so that became the pathway to violence. Does that answer your question?
A little bit. So, but the pathway to violence talks about, strike that. Let me rephrase. So you used the analogy of a cardiologist. You said this isn't predictive, it's preventive.
Right.
Right?
Right.
So this only applies after an event has happened?
No, not at all. That's how we have studied it. How we use it is in advance. So let's say, for example, you are a school principal and a child in your school has risen to your attention as raising concerns for violence for whatever reason. Maybe he's got a hit list, maybe he's stalking his girlfriend. So I would look at that if I were consulting with you, and I would ask for everything you know about the situation and the child. And I would look for evidence of these 8 proximal warning behaviors primarily that we know to be well correlated with subsequent violence, including the pathway. And if I saw evidence of any of those, then I would advocate for active management of the case to try to reduce the violence risk. The general rule is that once you observe 1 or more of the proximal warning behaviors, then some sort of active management is necessary to prevent violence. So we're managing behaviors of concern in the present to prevent violence in the future. We don't know that the child is ever going to be violent, but we're not waiting around to find out. We're going to take active steps to try to prevent and manage.
And you have no idea if absent those active steps, would that child ever have committed violence, true?
No idea is a bit strong, but do we know? No, we don't know. That's correct. Someone can certainly ride the pathway all the way up to one of the upper steps and then never do a thing. That's entirely possible.
All right. So you talked about that it has been subject to many studies. Could you tell me what studies this has been subject to?
Sure. Yeah, I was a little bit surprised to hear Dr. Fox say that it has been subject to no studies. The most recent study that was specifically on the pathway and only pathway came out in 2024 in the Journal of Threat Assessment and Management. And they had a very high, actually high inter-rater reliability score in that study. I would say the majority of studies in the last decade are more on proximal warning behaviors is the label that you would have to search by rather than pathway. They're on, almost more than I can count. Public figures, mass attackers, intimate partner homicide offenders, other sorts of family offenders like paternal filicide, maternal filicide, that kind of thing. Workplace, classroom. The journals are really littered with studies looking at proximal warning behaviors.
Are there any peer review studies that you can point to that adopt this?
All peer reviewed studies, all of them.
What are they?
Well, I supplied a list to Ms. Chevernak when they first contacted me, but the most recent one that I mentioned in 2024 is called "Are All Pathway Behaviors Observable, quantitative analysis of the pathway to intended violence model. And that came out in the Journal of Threat Assessment and Management.
So the same one you just told me about.
Yes.
Okay. All right, so it's not a predictive model, it's a preventive model. It's not capable, you can't generate any numerical score, correct?
No.
Using this. And it's not designed to determine if a specific individual is going to commit violence, correct?
No, I agree with Dr. Fox's description that it's a descriptive model. It describes behaviors that have been observed in studies. I would say its operational use is not in prediction, but in prevention, which I think is really a key difference in terms of how we use it in the field.
So it could be useful if someone came to the FBI and said they're thinking about a mass shooting.
I'm not sure I take your meaning.
Well, if it's not useful in predicting violence, and it's useful, as you said in your cardiology example, if someone comes in and says, hey, I'm having these symptoms, then, you can help prevent it. So how is this at all useful in the real world? Because people don't come into the FBI and say, I'm having these symptoms, and you can say, well, you are on the pathway to violence, let me help you. That doesn't happen, correct?
Yeah, that's never happened as far as I know, but how it is used is if I'm looking at a case where someone has already risen to the attention of whoever is observing as someone being of concern for violence, maybe they've been making threats, maybe they've been menacing people, maybe they have a hit list, whatever, that can look a million different ways. Then I look at the entirety of the case, as many facts as can be gathered, and then I begin looking for signs of proximal warning behaviors to decide if we're in, sort of an imminent countdown potentially to an act of violence. And that's where the pathway to violence becomes quite useful. If I observe someone on the pathway, particularly in late stage pathway markers, then I might develop, depending on the context, I'd have a lot of questions, but I might become very concerned that we're close to a potential act of violence.
Has this ever actually happened in the real world? Where you have stopped violence based on something that was brought to your attention?
Well,
how can you say that has happened?
We can't. That's what I mean by there's no prediction. I can't. So when we see pathway behaviors or other proximal warning behaviors, we intervene. That's our job, is to intervene. So once we've intervened and there's no violence, how can we ever say that there would have been violence but for intervention? You can't. You can't prove what never happened.
All right. It's fair to say that two evaluators could look at an individual and reach completely different conclusions, whether someone's on the pathway to violence or not, right?
Not well-trained evaluators.
So your testimony is that people always come to the same conclusion if they're trained in this?
No.
Okay. So people can come to different conclusions, even if they're both well-trained people?
I think if they're well-trained, they should not come to different conclusions on something as fundamental as the pathway. You can come to different conclusions about how close someone is to violence.
But it's subjective, right? It's not based on scientific data.
Well, it is based on scientific data. All those studies that I referenced in the 80s and 90s that helped Brian Foscule, Randy Borum, and Robert Fine arrive at the pathway to violence, that's data.
The journal we talked about, that it was published in.
No, that's a different journal. There are dozens of studies, but we're talking about the study I referred you to was in 2024, just because it's the most recent one, specifically on the pathway and only the pathway. But the journals I'm talking about we're talking like 80s and 90s.
There's no way that the model can tell us how often it produces false positives, right?
Correct.
And you can't tell us the model's error rate. True?
Correct.
You can't quantify the likelihood that an individual identified as being on the pathway will not commit violence.
I can't quantify whether they will or will not. It doesn't work that way.
Yet you believe you could apply this framework in this case?
I don't know anything about this case, actually.
Well, you know what the defendant's charged with.
I believe it's a homicide, but I don't know any facts and circumstances or if there are other charges.
Okay. Are you familiar with the case United States versus Wells?
I am not.
Isn't Agent Malloy a colleague of yours who helped write The Pathway to Violence?
Agent Malloy? Oh, Dr. Reed Malloy?
Yes.
He's not an agent. He didn't write The Pathway to Violence, nor did I.
So you're not aware, you gave the example of workplace shooting.
Okay.
So you're not aware that that is the exact case that was rejected as the science being unreliable in the United States versus Wells. You're not aware of that.
I'm sorry. I have no idea what you're talking about.
All right. Have you testified in a homicide trial about the pathway to violence previously?
I have not.
Have you testified as an expert previously?
I have not.
Can you give me any examples where the pathway to violence was used in?
Okay, I have to say that she does not seem to be a credible witness. But also, the defense team back there needs to get their act together and tell Corey to quit smirking and smarting, laughing and all that junk, because that's just stupid and gross. And I'm sure the judge doesn't appreciate it.
In the courtroom? At a homicide trial after the fact?
I don't know.
Okay. I have nothing further.
Ms. Sherbanek, anything further?
No.
Okay. Ms. Ammon, thank you. You're welcome to turn off your video and your camera. Why don't we take a 10-minute break and then we'll come back. Thank you. Come back at 11:10. Thank you. Court's in recess. Manuel.
Seriously? Why didn't y'all tell me? Sorry, I didn't realize I was muted. I'm sorry. Hey, Brenda, good to see you. I was talking about the guy in the cowboy hat. Sorry. I'll fast forward it. Okay. You all were checking your volume. Sorry. And while I had my camera off and the thing muted, I went like this to grab something on the other side of my desk, not paying attention, and knocked the whole microphone off. It went flying in the floor and everything. Yeah. Sorry. I'm glad that the microphone wasn't muted, or I'm glad that it was muted then. All right, come on, judgy judge. Oh, hold on. Let's get with the program. What's the guy's name? What was his name? You guys, did you all, you know how I am about faces and actors and stuff. Do you know who this man reminds me of? What was his name on The Walking Dead? That old man that had that farm and he had the two daughters, Maggie and the other one. Or maybe they were his granddaughters. I don't remember. I think they were his daughters. And he was an old man. Do y'all remember that? What was his name? I loved him. Oh, I can't remember what his name was. But that's who this judge reminds me of right now. Why? I don't know. Herschel. Yes. God, I loved him. Loved him. Herschel. That's it. Don't he remind you of him? Just like a younger version of Herschel? I don't know. I think it's the beard and the hair. I don't know. But yeah, that's who he reminds me of, Herschel. He was such a good character in that show. Oh, poor Herschel. Okay, going a little. Speed it along. Speed it up a little. And now he gets up and walks off. All right, let me.
For my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Okay, let me rewind this. Hold on.
Ms. Mitchell? Ask the defense strategy, which defense exhibit.
All right, here we go.
Handing you defendant's exhibit A. I did not file it because
Don't pay attention to things that comes out of Gail's fingertips when she talks. I mean, I'm the one that said, oh, poor Herschel. But, you know, I mean, if you ain't been spoiled for The Walking Dead by now, then I don't know what to tell you. I mean, just saying. Just know everybody dies. Okay? Okay. Or just assume everybody dies. All right, here we go.
with the filing system and it is our defense strategy.
And Maria Chavez, who are also my notes on witness Aaron Robin and Maria Chavez, who are also teachers that would be located on the south end of the building.
Yeah, that's true. I don't know that. Yeah, there's lots of yelling, Donnie. I mean, people are running for their lives and getting smashed in the head. And yeah. It's very gruesome. Very. I mean, it will give you nightmares. It's a good series. It's a good series. But not for the faint of heart. Yes, scary and lots of yelling. Yeah, lots of yelling. I don't mean like yelling as an arguing yelling. There is some of that, but there's a lot of yelling and there's a lot of yelling. So I'll say that. I've not watched that in a while. I haven't watched. I won't say, but there was a specific part that I quit watching because I got mad, and I haven't watched any more since then. So, yeah. But anyway, another spoiler from Mrs. Savage. Really, Gail? Reruns of Designing Women. There you go. There you go. There you go. That's the perfect one.
Okay, these also were tendered to me in camera, so they'll be
Those
sealed
were
as
awful
well after I
flashy
review them.
shoes. Those were awful flashy shoes for a lawyer in a trial, weren't they? Hold on. Look at these shoes. Check these shoes out she's got on. They're pretty, but for a courtroom?
Features that would be located on the south end of the building.
Okay, these also were tendered to me in camera, so they'll be sealed as well after I review them.
Pretty, but not professional.
I just wanted to also clarify for the record, Your Honor. So yesterday when I testified, after I testified, I, off the record, told opposing counsel, and I want to put this on the record, that I had not reviewed Stephanie Hale's interview with the Rangers at the time that she appeared for trial preparation. I went back to my notes. We interviewed her on December the 10th.
Right.
At that time, I had not reviewed her testimony to the Rangers. It wasn't until the week of Christmas, I think all around December 26th, is when I started pulling the witness interviews with the Rangers that I reviewed her actual testimony to the Rangers. So the position that I could have had an epiphany on December the 10th when we interviewed her in anticipation of the trial is misplaced. And I just wanted to make sure that that was on the record to clarify.
Yes, Your Honor, and our position on that would have been the epiphany should have occurred on the 26th.
Okay. Okay, well, I'm going to review these documents that have been tendered to me in camera, but I will obviously at this point take any motions or arguments as far as remedies or proceedings in this matter. So, defense?
Yes, Your Honor. So
I understand high heels. I mean, that's not the problem that they're heels. They were just flashy and like silver, bright, blingy, and the heel in the back. I mean, when I think of like professional lawyer attire, I think of power heels, but closed toe and closed heel. You know what I mean? But still, we've seen some good shoes in these courtrooms. I like these, just not for court.
as the court will see from the
Kind of, Mr. Savage. That's kind of where I was going.
This did have this situation did have a significant effect on the strategy.
You said it for me.
From Vordaer all the way through, and through future witnesses, should they be called. We're in a position where we know under the law that we have to ask the court for a mistrial to preserve the record. However, if the court was not inclined to grant a mistrial, we do have other remedies we'd like to discuss.
Well, let me just say this, under Heath, the greatly awaited case from the Court of Criminal Appeals about the court's discretion and power to basically, if there is a Brady violation or a Morton violation, to have the ability to exclude that testimony. And they clarified that the prosecutors, it does not have to be an intentional act. And I'll say for the record that I find, based upon what we heard yesterday, that this was not an intentional act. At best, it was a negligent act, or at worst. So I do have the remedies under Heath available, but if you're making your motion for mistrial, I will tell you, I don't believe what I've heard so far without reading although I have summarized what you gave me, and I kind of already had an idea of what it was. So I guess my question is, since we talked about yesterday, the three things that were complained about was the puffing, her seeing the dirt being puffed up. Number two, identifying or saying that she saw the individual for the first time, and the location. All right, my question is on the location issue that she testified to yesterday, and frankly, I think that was kind of very quick testimony. I'm not sure that it resonated with the jury, but my question is there going to be other witnesses that put that individual in the same location that are going to be called later by the state?
Your Honor, I would say the most probably compelling testimony are the casings in the case that would either corroborate or override what she said. I believe.
Right, Donnie? Donnie said, I went back to see the heels. They were a bit much. Right? I mean, I'm a prude, but I'm not. Y'all have to agree, those shoes were a little bit too risque for court. I mean, you could probably get away with wearing them to church with the right outfit. I mean, maybe even what she's got on and go to, but to court, I don't know. It just seems weird for court. I don't know. Seems weird saying you could wear them to church, but not court, though. Like, if they're too much for court, how could they not be too much for church? But it works at church, too. I mean, you could wear that kind of thing to church and nobody be like, oh, she's a hooker. You know what I mean? Maybe. I'm kidding. Lady, if you ever watch this, they're gorgeous shoes, okay? You have really pretty shoes. You have great taste. You have great legs, even. I noticed your calves. You have great legs. I just don't like those shoes in the courtroom. Sorry. It's just different, right, Brenda? Yeah. All right, I'm sorry. I keep going on and on about these shoes. Let's go.
The location that she placed.
I couldn't wear them even if I wanted to.
100 yards away.
They are pretty. I couldn't wear them if I wanted to. Maybe it is the strap on the back. I think it is. Maybe if it wasn't for the heel showing, maybe that's what it is. If it had a heel on it, or not a heel, but the strap, her heel is shown. I think that's it. I feel like the whole foot should be covered. I don't know. A sharp black pump would be just more classy. And yeah, absolutely. We saw one chick one day. Y'all remember that chick we saw? I don't remember what trial it was. But she had like what was it? They were like red stilettos. But they were bougie. I mean, but they were nice. I mean, she looked good, you know. Why did you just tell John you quit? What'd you quit for? Sling back still feels weird. Yeah. What'd you quit, Morgana? Trying to watch this? I bet she said, I quit trying to watch this trial because Jenny won't quit starting and stopping. Well, she's going to come back and say, I told John I quit trying to watch this because Jenny won't shut up. I'm zipping my lip. Being a diabetic. Oh, well, I mean, I don't know if you can quit that or not. Slingback, that's the word. Yeah. She says being a diabetic. She quits being a diabetic. Gail said cleaning, cooking. The judge in Parkland had super flashy heels. I wonder what kind of shoes Jennifer Darrow wears. Y'all know I love her. I don't think that's possible, hun. Right, Gail? I don't think so either. No. I don't think so. Nice try, though, Morgana. I really wish that you could decide to just quit and be done, and you wouldn't have to worry with it no more. Wouldn't that be the greatest thing? If it were only that easy, right? All right, here we go. So sorry.
Toward the south end of the building, and she puts, I believe she marked in a general area south of the building.
Sorry.
The casings are going to be closer toward the west side of the building. That is, they're going to be further west by as much as 10 yards. I haven't figured the exact date. So a witness from 100 yards away, placing a witness within a 10-yard distance, that would be the distinction. The other potential witness, Melanie Flores, testified that, would testify that the gunman, as she saw the children go into the south door, she saw the gunman at the south and west corner of the building, which I believe her testimony will put it halfway between where the casings were and where this witness says it was.
Okay. Well, I did a little research last evening, and again, I don't want to. I've reviewed your in-camera explanation of how this affects your defense strategy, and I'd already kind of gleaned what it was. So I can tell you, I'm going to deny the motion for mistrial. You have made it, and you've preserved your record. Again.
Yes, sir. In addition, can I just, so I can make sure it's clear, because we all know how the courts start interpreting it later. We will go with whatever remedy the court decides that we can decide it. However, we do not believe that it's a sufficient remedy, and mistrial would be the.
Yeah, I'm going to deny the motion for mistrial over your objection, obviously. And I'm going to find under Heath, although it's not a prerequisite, that it was not intentional by the district attorney's office. It was negligent. And I don't believe what was testified to in front of the jury resonated enough to significantly affect your trial strategy. But what I am going to do under Heath is I'm going to exclude her testimony.
We have before you do that, really, I just want to know we have a response to if you would consider that. So.
We would also have a response to that, and just so we can explain to the court that our primary concern with an exclusion is that basically what's happened, and I understand the jury, and you'll instruct the jury to disregard. I think a lot of that testimony, though, is going to be difficult for them to disregard. A lot of it is emotional testimony. One of the things that we were thinking about as a remedy would be to allow us to play her statement to the Rangers in its entirety to the jury so that they can hear what she said in the first 4 days.
Well, I was going to give the option of, even if I exclude her testimony, you still, if you wish, could cross-examine her and do that.
Okay.
And then at the conclusion of that, my thought could be to exclude it at that time.
Yes, sir. It's not, because I guess my concern would be if we excluded it now and they haven't had an opportunity for.
I was going to give you that choice, but you jumped ahead of me.
Sorry, Judge. I'm sorry. I got a little afraid. I'm sorry.
All right, Ms. Mitchell, what do you have?
Your Honor, we just have a state response to the defendant's motion to exclude the testimony of witnesses SH in anticipation of their motion. So I just want to file that with the court for the court's consideration. You can file this copy too.
Okay, well,
And that's my copy. The first copy is for the judge. I'm sorry.
okay, thank you.
I just want to file that.
Okay, so again, this is kind of a sua sponte remedy that I've devised. It's not really their motion.
Watch, she's basically just going to say, oh, well, I'm just going to tell the jury to please just disregard what she said. But they're not going to want him to bring it up like he was talking about. You don't want him to bring it up, really, because if they weren't thinking about it and didn't really hear it, and that hasn't entered their mind, then him saying it will. So how do you fix that? You know what I'm saying? How do you fix it? She's like, John doesn't like to put dishes. It's exactly right, Morgana. Actually, I don't mind putting dishes in the dishwasher. It's taking them out of the dishwasher and putting them up that I don't like. I can't stand that. Yeah, you still have to load it and unload it and put everything away. I don't mind loading the dishwasher. I actually enjoy that because I get all the dirty dishes out of my sink. But I hate unloading the dishwasher. And you would think that it would be the opposite, but it's not. For me, I hate putting dishes away. I hate it. See, Morgana likes it. I like filling the dishwasher. But when I start really thinking about it, maybe it's not the dishes that I would do without so much as it would be laundry. I hate doing laundry. I hate doing laundry. So it isn't just, okay, we should be, Morgana. Will you marry me? Margaret hates emptying the dishwasher too. Right, Mary Lou? Poor me, my dishwasher's at the end of my elbows. Gail's going to say the same thing because she does dishes by hand too. Now, I do a lot of dishes by hand. I do that anyway. I actually have always liked doing dishes. For whatever reason, I don't know why. I've always liked doing dishes. Now, when I have two sinkfuls full, no, I don't want to do dishes. I want to throw them in the dishwasher. So that's what I do. But I do like to wash dishes, especially I end up usually washing all the big pots and pans anyway. So, all right. Okay, here we go.
Did you file a written? Did you file something?
No.
Okay.
This is just anticipation of an oral motion to
Okay.
exclude Your Honor.
Okay.
I don't know, Your Honor, can we confer as to possible remedies? And see if we can come up with a solution? Would the court be open to that?
I mean, if y'all agree on a remedy, I'm happy to entertain that, but I want the record to reflect that pursuant to Heath, I do have, discretion to craft a remedy any way I see fit. But what I've already done, for the record, is we have given a continuance to the defense until tomorrow, and we're having a hearing outside the presence of the jury to entertain potential remedies and make findings of fact if necessary. But for the record, there was a motion for mistrial, and on that motion for mistrial, I'm going to find it's denied because I think the remedies available are sufficient to protect the due process rights of the defendant. And if y'all want to agree on a remedy, I'm happy to entertain that, but I have one in mind, and I'm going to give the defense some leeway on how they want to proceed with the witness in front of the jury in the event she's recalled after we talk. So take 15 minutes, y'all talk, and we'll come back into court, and I'll review the state's response to the oral motion and finish the other in-camera matters that were submitted to me. But is there a place, if you want to just go back to my office, I'll stay here and you can go back to the office that they've provided me.
We have a room actually that they've given us over here that's.
Or you can go, actually you can go to the jury room if you want to, because nobody's there. But I'm assuming that contemplates conferring that everybody goes, the state joins you. Okay. That's fine. All right. Well, y'all let me know. We'll be in recess till you come back.
Okay, I fast forwarded.
Okay, she's ready to go. We're on potential remedies in regard to the witness. So what do y'all have to report?
Judge, we've had pretty good, pretty productive talks, and I believe, and correct me if I'm wrong on any of this, that the proposition at this point, with them still reserving the right to think of it overnight and start in the morning, is that they continue their cross-examination. They get to also play the entire statement that she made. We would then get to redirect, and then they still reserve the right to ask you to exclude all the testimony. And
Yeah.
that part we feel comfortable.
Yes, Judge, and under the idea that we want to unring the bell first before there's an instruction to exclude it, because and have them exclude it all in its entirety, which is fine. But we would like to be able to unring that bell and then make that decision. Depending on how that cross-examination goes, we might not ask to exclude her, because there are some things that she says that we're just trying to evaluate her testimony after it is to see, on balance, is it more beneficial to our case or is it not? Like, after we've unrang the bell. But if we determine on balance that it's less beneficial, we would still like to have the Heath remedy for the late disclosure.
Well, for the record, I'm offering it right now. I'm offering the Heath remedy to exclude her testimony immediately. But if y'all want an opportunity to try this, if both sides agree, I'm happy to implement that agreement.
Yes, Your Honor. What we believe is ultimately we believe we're asking the court to exclude. The only issue is that we just want to be able to unring the bell first.
All right.
Is the idea.
And I know I told her, but she knows she's supposed to be here at 9 o'clock tomorrow. Okay.
Yes, Your Honor. Additionally, I will say that that in light of it, whatever harm that the court has determined in the defense case strategy or in emotional impact, we would add that, and we do believe that under our 403 motion and motion of limine under the autopsy photos and the like, that it would start to, that the court should add that in the 403 balance, because part of what was not disclosed is something that is, I guess, on an emotional level, especially in what this witness testified to has a tendency to prejudice the defendant. She was taking shots. She was actually personally traumatized by these things that we are going to show that she has never said before. But the jury, having heard that, we believe that it should be a part of the 403 balance when the court eventually, I know you haven't made your final decision about what it is, but I would just, for the record, I would say that it can compound the harm if there's a disclosure, and then the probative value, whatever that is, of them trying to get into these photos of these children are the prejudicial danger is compounded by something like this occurring in the trial, as to how it can affect the jury. And so I just wanted to put on the record now, I know the court hadn't made the decision, but just to put that in the court's mind that we are also going to be arguing that at a later date.
All right.
And Judge, I just wanted to be clear, because I originally heard the court say, I'm willing to strike all the testimony now, but I'm also willing to entertain the defense's claim.
I want it on the record, because I've denied the mistrial, that in lieu of the mistrial, I'm ready to exclude the testimony now. But if you all want to agree on this, then I will implement your agreement.
Could you give me 1 minute then?
Yeah, and I guess yes, I think just the court understanding, willing to strike now would the only reason we're not accepting that. What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how can you claim that the mistrial was wrongfully denied, right? So what I want to do is just say that the reason we don't believe that striking it now, and like she just goes away, is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Right. You see what I mean? And so, what it does is it puts us in a situation where that remedy could actually harm our client worse. All right.
Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we resting, or actually she's finished with redirect and recross, whatever the case may be.
Yes, Your Honor.
But my recollection is she's on cross now.
She is.
Okay.
We left off where I was refreshing her with her statement, and then that's when this issue came up, and so I would just continue with the cross-examination.
They passed her and she's on cross.
Yes, Your
now.
Honor.
Okay. All right. Very good. All right. So 9 o'clock tomorrow with the witness, and we will proceed at that time. Thank you very much. We'll be in recess.
Okay, I couldn't hear what the prosecution said. I'm going to go back because it sounded, the way he asked that was kind of like, so is that offer still on the table? You know what I mean?
Well, all right. Well, we'll let the defense proceed as we just discussed.
Shoot,
and,
hold on.
Remedy, right, goes away. What I want to do, then the courts later, I'm on the record saying that I don't.
Because see, he goes, the guy in the gray suit comes back and asks her something. And then he goes back and says, we want to blah, blah, blah. And I didn't hear what he said.
What I don't want to do is be in a situation where I'm on the record saying that I don't want that court's remedy, because then the courts later will say, well, then if you didn't want the court's remedy, then how do you how can
I'm
you
leaning
claim
in
that the
like I
mistrial
can hear
was
what she's
wrongfully
saying.
denied, right? So what I want to do is just say that the reason we don't believe that striking it now and like she just goes away is that we'll never have an opportunity to unring the bell.
And we think that the court's remedy of striking it all now is sufficient.
Okay, there. That's what
Right,
he
you
said.
see-
He said, and we think now that the court's suggestion to strike it all now is sufficient. So he kind of came back and changed his mind, changed his tune. Dirty.
But I mean, and so what it does is it puts us in a situation where that remedy could actually harm our client worse. By
All right. Well, we'll let the defense proceed as we just discussed, and she needs to be here at 9 o'clock in the morning, and then I'll make a decision on exclusion with everybody's participation after we rest and or actually she's finished with redirect and recross, whatever the case may be.
Yes, sir.
No, don't get me wrong. I'm not like saying that the guy's innocent or nothing like that. I mean, I just think that going back and making a plan and then coming back in front of the judge, and then the judge is like, oh, well, here, I was going to give you $1 million. And now the prosecution is like, oh, well, forget you. I want the $1 million. That's kind of how I took that. He just kind of ran the defense over with the bus. Oh, well, I am going to go ahead and get out of here. Husband is going to be home soon with dinner. We're having dinner tonight. I don't know what he's picking up, but anyway, that's what we're having for dinner, whatever he brings home. And I am going to help kiddo with her homework and all that jazz. So I will see you guys back tomorrow at some point. Yeah. I guess we'll check back in with court tomorrow here, and probably Corey Richens, see what kind of stuff we missed. I need to kind of check through and do a recap of that. Because that hearing, the evidentiary hearing for Corey Richens is supposed to last for 2 days. So anyway, thank you. Thank you, Lindsay. Thank you, Donnie. You too. You have a good night, Gail. Love y'all. Love you, Markina. Bye, Cherie. Have a good night. Thanks for hanging out. I'll see you guys tomorrow. Love you. Bye.